You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant. Defense ready to proceed? Okay, let's return the jury. Good morning, ladies and gentlemen of the jury. Did you heed my previous admonitions over the evening? Thank you. Does the state recognize the presence of the jury? Does the defense? Okay, the defense may call their first witness.
Calls Gerardo Bloise.
Raise your right hand and answer out loud.
Solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good morning. My name is Gerardo Bloise, Gerardo, Bloise, last name, Bloise, Bloise.
May it please the court.
You may proceed.
Mr. Oen. Good morning, ladies and gentlemen. Good morning, Mr. Bloise.
Good morning, Counselor.
Mr. Bloise, we've already know you work as a crime scene investigator for Orange County.
Correct.
Okay.
Yes.
And rather than go through your qualifications, I'd like to just jump right in, if that's okay.
Okay, no problem.
Sir, on Wednesday, July 23rd of 2008, you were asked to inspect a vehicle. Were you not?
Wednesday.
Yes. If you
July?
want, you can refer to your report.
Say Wednesday, July 30th,
23rd.
23rd.
Yes.
Yes.
Okay. And who did this car belong to?
Anthony Lazaro, Tony Lazaro.
Okay. And what you did at this time was you did a vehicle inspection of the exterior and interior of the car.
Correct.
Okay. And part of that was you also wanted to check the car with an alternating light source.
Correct, yes.
And you also did a presumptive test for blood, did you not?
Yes, I did.
Sustained. Rephrase the question.
Can you tell us everything you did with that car?
I inspected the vehicle exterior, interior, and also I checked the trunk area, and I observed some stain on the carpet. Before that, I used alternate light sources, give me a positive reaction for stain. Next step is I use a presumptive blood test in that area, and the result was negative.
Okay. And is it your experience that the alternating light source, the purpose of it is to tell you where to look further?
Yes.
Okay. So it's just basically a tool that people's cars have stains, and that's where you should look.
Sustained.
How does the alternate light source assist you?
The alternate light sources is tools that we have in order to detect any kind of reaction for body fluids.
Okay. And then your next step would be to do what?
Next step, if I observe any suspected stain, I proceed to do a presumptive blood test.
Okay. And you did that, and what were the results?
Negative.
Okay. And you also then did what next?
After that inspection, photographed the interior, exterior of the vehicle, and that's it.
Okay. Did you place the car on a lift at all?
No, I did not.
Okay. And can you check your report and see if there was anything else you did?
Yes, I did, but this is the other vehicle.
Okay.
That was the Sunfire vehicle.
But you didn't indicate that on your report, so I just wanted to clear that up, right?
Yeah, in the out-of-death garage, I mentioned at 13 hours that I moved the vehicle from the forensic garage, which was the white Pontiac, to the lift.
Okay.
Yes, it is in my report, but I don't mention the
You don't mention which vehicle.
tag number exactly, yes.
Okay. Now, did you collect any items from Tony Lazzaro's car of evidentiary value?
No.
Okay. Now, I'd like to take you to August of 2008, August 6, 2008. Can you tell the ladies and gentlemen of the jury what you did on that day?
August 2008?
Yes, August 6, 2008.
May I refer to my report, please?
Yes, you may.
Your Honor? Thank you, sir. That was a search warrant
And where was this search warrant executed?
at the residence of the Anthony's family.
Okay. Would that be the home on 4937 Hope Spring Drive?
Yes.
Okay. And what was your assignment to do that day?
And that day, that was to check the bedroom belongs to belongs to Casey, and then to check for clothing, and inspected clothing with using ultralight sources, and then collected some pieces of clothing from the bedroom.
Was part of your assignment to search any other rooms?
Not to my best recollection. The only things that we checked was the living room area and the garage area, the car, the vehicle, and that's it.
Okay. Did you check George and Cindy Anthony's room?
I just did visual inspection. I don't remember if I used any kind of light sources, to my
Okay.
best recollection.
But you did do a visual inspection of, excuse me, let me strike that. You did go further in Casey Anthony's room.
Yes, correct, yes.
Okay. I'd like to show you a series of photographs identified as Defense Identification Exhibit X, Y, Z, AA, AB, AC, AD, AE, AF, AH, AG, AI, and AJ. May I approach the witness, Your Honor?
You may.
I'm showing you now. I'll speak loudly. I'm showing you now Defense Exhibit X. What does that appear to be to you, sir?
That was the bathroom,
Who's better?
Casey.
And is that a fair and accurate representation of the bedroom as it appeared on that day to you?
Yes.
Unless there's any objections, I'd like to move Defense Exhibit X into evidence.
I reviewed this series of photographs. I have objections from none of them.
Okay.
Remember, if you don't have microphones on the court report, do you want to lavalier mic, Mr.
I'm actually going to go back here.
Okay. State had no objections to that exhibit?
Correct, no objection.
Okay, it will be received. Did you give it back to the clerk?
Yes, sir.
It will be received in evidence as defense exhibit numbered.
Your Honor, in light of the state's agreeing on these items, I'd like to just go ahead and enter them all into evidence, if I may.
State, any objections?
No, I've reviewed them all. There's no objection.
Okay, they will be removed. They will be received in evidence as the next announced exhibit numbers. Please hand them to the clerk so she can mark them and announce them.
Defense Y will become defense exhibit number 3. Z will become defense exhibit number 4. AA will become defense exhibit number 5. AB will become defense exhibit number 6. AC will become defense exhibit number 7. AD will become defense exhibit number 8. AE will become defense exhibit number 9. AF will become defense exhibit number 10. AG will become defense exhibit number 11. AH will become defense exhibit number 12. And AI will become defense exhibit number 13.
May I publish Defense Exhibit 2 to the jury, Your Honor?
Yes, you may.
Yes. Okay. Yes, sir. All right, got it. Okay. Sir, can you see the photograph?
Yes.
Can the ladies and gentlemen of the jury see the photograph? Okay. Now, sir, can you describe the room basically for us?
It's a single bed and some pillows on the bed, nightstand, a dresser.
What is this item here?
It's like several pictures.
Okay. And what would be behind this wall here?
The closet.
Okay. And tell us what your goal was to do that day. What were you there to do?
In that day was to collect some pieces of clothing from the closet and check those items at the bathroom with the internal light sources, and then collect the clothing, the pieces of clothing.
Okay. And was it your understanding that you were going to look at the clothing that had, well, let me rephrase that. Was it your understanding that you were going to now look at all of Casey Anthony's clothing?
Yes, just to check the bathroom, yes, clothing.
And what was your goal in looking at all of her clothing?
My goal is to inspect the items with internalized sources. If I see any suspected stain, and then collect the items that I observe some suspected stain.
Okay. And tell the ladies and gentlemen of the jury how you go about doing that.
I just put some black cover on the window.
Why do you do that?
In order to get the room dark, and then use the internalized sources, which give me some fluorescent light. And then when I inspected the clothing, I be able to see any suspected stain. And then if I see any suspected stain, and then I separate that item and put it in the paper bag, and then collect as evidence.
Okay. Let me take you step by step if I can. What is this photograph that you're looking at now?
That was the closet.
Okay. And that is that where you got all of the clothing from?
Not all of them. Some pieces of clothing, yes.
Okay. And you also checked the drawers in the room?
I don't recall if I checked the drawers.
Okay. Do you believe you would have done a thorough job in checking the entire room?
Yes.
Okay. And I'm going to show you some clothing. I'm showing you now defense evidence 5. Is that one of the items that you inspected?
Yes.
Okay. Is that one of the items that you had found a suspected stain on at all?
Let me check the tag
Sure.
because it's
No
have
problem.
an ID on it. Number 1, Your Honor, may I refer to my report to refresh my recollection? Thank you, Your Honor. That was the charcoal gray pants, brand name Zinc Sci-Fi, tag number H52175. I checked the item with ultralight sources. No stain was found.
Okay. Was it your understanding that these pair of pants were the pants that Casey was seen wearing on June 16, 2008?
I was informed that she was wearing that pants, yes.
Okay. And you found no stains on those pants?
No.
Now, I'd like for you to describe exactly a little bit more of what you did. You put black paper on the windows, correct?
Correct.
And the purpose of that was to make the room as dark as possible?
Yes.
Okay. And then what do you do when you take one piece of clothing at a time and inspect it, or how does that go?
One piece at a time.
Okay. And do you photograph certain stains as you see them?
Yes, I did.
Okay. And I'm going to show you Defense Exhibit 14. Is this what the stains appear to you under the alternating light source?
Yes.
Okay. And you photograph them to document them, I presume?
Yes.
Okay. Now, when you see something like that, that's, I guess, pants, a stain on the bottom of someone's pants, correct?
Yes, look like, yes.
Okay. What do you do with an item like that?
As soon as I observed that kind of stain, what I did, I submit those items to the FBI lab.
Okay. And that would be a large stain in under your, well, I'm sorry, I don't mean, describe to us, would you consider that large, small? How would you describe that?
You can say like a medium
Okay.
stain, yeah.
I'm going to show you now Defense Exhibit 12. And is that another example of another piece of clothing?
Yes.
Okay. And what are we seeing here, sir?
In this picture, you can observe some scales and arrow that shows the indication that I found some stain.
Okay. Now, would you classify those as small stains?
Yes.
Okay. And these are the types of details that you're looking for, are they not?
Correct. In clothing, yes.
Okay. And do you even get more detailed than this as far as stains are concerned?
No, that's it. Just stain like that.
Okay. Okay. After you have inspected all of her clothing, what did you do next?
Then I proceed to packaging in every single item in a paper bag and submit it to the FBI lab.
Okay. Now, when you do this inspection, what kind of protective gear are you wearing?
Was wearing the lab Tyvek.
Okay. What is that?
It's like a jumpsuit.
Okay. And does that have a hood or anything like that?
No.
Okay.
Just
What
Tyvek.
about-
And clothing? I mean gloves.
Okay. So you have gloves on. You have a white jumpsuit, is it?
Yes.
And what about foot protection? Anything there?
No, it's in the lab.
Okay.
In a forensic lab.
Any hair nets or anything to prevent your hair from falling on?
Hair nets, I use hair nets, yes.
Okay, so you're in full gear.
Yes.
Okay. And do you speak while you're doing these things?
No.
And why not?
Huh?
Why not?
Because I by myself.
Okay. You mean you don't talk to yourself? All right. Now, let me ask you this, Mr. Bloise. Was Alina Burrows with you?
Excuse me. Yes.
Okay. So, did you talk to her while you were doing this?
Oh, if you refer to this picture,
Yeah.
I took those pictures in the forensic lab.
Okay.
Okay.
So,
I'm by myself.
Okay. So if we're all to understand what you did, you inspected the items in her room and then decided which ones you were going to take. Is that correct?
That's correct, yes.
Okay. And then you went to the lab and you photographed them like this so we could see.
Correct.
Okay. But while you were doing this in Casey's room, you were also with Miss Burrows, another CSI person.
Yes, she was with me.
Okay. And was Detective Yuri Melich with you as well?
Yes.
Okay. Did he go in the room or was it just the crime scene investigators?
No, he spent some time with us inside the room, yes.
Okay. So he was made aware of all that was going on and all that was being taken from the home?
Yes.
Okay. Was there anything else you did in regards to this search warrant?
That's it. That was my whole involvement in this search warrant.
Okay. And then part of your job at that point would be to do what with the information, what with these items of evidence?
Submit it to the FBI lab.
Okay. And how is that done?
I just photographed the items, prepared the letter to the FBI lab with the pictures that I observed a suspected stain, and submitted with the property forms that we have as an agency, as the Orange County Sheriff's Office property form, and then submit the items to the FBI lab.
And are these items of evidence protected in any way from further contamination?
Yes.
How so?
It's a paper bag. I seal it and put my initial on it.
Kind of like some of the bags that we see here today?
Yes, sir.
Okay. I have no further questions.
Cross-examination.
Investigator Bloise, the scope of the search warrant that you were just speaking of was to locate clothing items of Ms. Anthony's only, correct?
Just my best understanding, yes.
And it is also your understanding that the pants that you were looking for as perhaps a garment that Ms. Anthony wore on June 16th of 2008 had been washed by her mother.
Yes, she informed me that she washed the particular item, yes, she did.
When you inspected Tony Lazzaro's Jeep, you recall
Yes.
doing that?
Yes.
Did it smell like there had been a dead body in it?
No.
No further questions.
Redirect.
When you inspected Mr. Lazzaro's car, did you find a bag of garbage that had been in there in the trunk for 3 weeks?
No.
No further questions.
May the witness be excused. Thank you, sir. You may be excused.
Thank you, Your Honor.
The defense may call their next witness.
Please, ma'am. Stand here, please. Raise your right hand.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. Swear, please.
My name is Heather Sebert. Spelling of my last name is Seubert.
Good morning, Ms. Sebert.
Good morning, sir.
Can you tell us what is your occupation?
I am currently the unit chief of the Firearms Tool Marks Unit at the FBI laboratory located in Quantico, Virginia.
Okay. And in 2008, what position did you hold with the FBI?
In 2008, I was one of the supervisory forensic DNA examiners in the DNA analysis unit, also at the FBI laboratory.
Okay. And how is the DNA analysis unit broken down at the FBI laboratory?
Well, currently there are actually 3 three DNA units. There is the mitochondrial DNA unit, the nuclear DNA unit, and the federal DNA database unit.
Okay. And could you give the ladies and gentlemen of the jury just a brief synopsis of what each unit does?
Sure. In the mitochondrial DNA analysis unit, that unit's responsible for examining items of evidence for mitochondrial DNA typing. And the types of evidence that they receive are typically samples, bone, hairs, and teeth. In the nuclear DNA unit, the unit's responsible for also examining items of evidence for the presence of biological fluids such as blood and semen, and then examining those stains for processing them for DNA typing. And then in the federal DNA database unit, that unit does not receive any items of evidence. Its mission is to process samples from known convicted offenders for entry into the National DNA Index.
Okay. And how long have you been employed with the FBI?
Just about 12 and a half years. I started in October of 1998.
And with whom were you employed before the FBI?
I was employed with the Department of the Michigan State Police as a forensic scientist in the forensic laboratory located in Lansing, Michigan.
And what is your educational background?
I've received a Bachelor's of Science in Forensic Science from Michigan State University located in East Lansing, Michigan.
And have you taken any additional coursework in the area of DNA analysis?
Yes, I have. I'm actually currently enrolled in the graduate program at the University of Florida out of Gainesville, Florida, in a master's program focused on forensic DNA and serology. And I've also taken coursework through the George Mason University, which is located in Fairfax, Virginia, in the areas of statistics and genetics. And I've also taken a molecular biology course from Lansing Community College, located in Lansing, Michigan.
And have you taken any specialized training while employed with the FBI?
Yes, I have. I actually started as a biologist in the mitochondrial DNA analysis unit when I started with the Bureau in 1998. And so I was trained and qualified as a biologist, so I had undergone a specialized training program to perform DNA typing on bones, hairs, and teeth. And then I was promoted to a forensic DNA examiner in 2001. And as a part of that program, or that position, I was trained and qualified under the supervision of a qualified DNA examiner to perform those job duties. And then I had also spent time in the federal DNA database unit, so I underwent a truncated training program to be a qualified database examiner as well.
And could you tell the ladies and gentlemen of the jury what is serology?
Sure. Serology is the science involved in identifying biological fluids such as blood, semen, and other biological fluids.
Okay. And have you received any training in serology?
Yes, I have. When I started with the Michigan State Police, I was devoted most of my time as a serologist in that position, and so I was trained and qualified as a serologist to examine items of evidence for blood and semen. And then when I started in the DNA analysis unit as an examiner, I also, as a part of my training, underwent some serology training there as well.
And have you done any teaching or public speaking in the area in the fields of forensic science?
I have. As one of my job duties with the FBI was one of the primary instructors on the FBI's quality assurance standards. And so I did that for a number of years and probably provided instruction to well over 1,000 DNA analysts on what are termed as the quality assurance standards, which laboratories performing DNA typing and entering DNA profiles into the National DNA Index have to comply with. And so I provided instruction on that for a number of years. And I've also presented at conferences on the area or in the area of the quality assurance standards and provided also specialized topics in DNA at conferences as well.
And are you a member of any professional organizations of forensic science?
I am. I'm a fellow of the American Academy of Forensic Sciences. I am currently one of the proficiency test review members for the biology section for the American Society of Crime Laboratory Directors, Laboratory Accreditation Board, and I was the vice chair of the scientific working group on DNA analysis methods, but I retired from that position in January of this year.
What does that mean, the scientific working group for DNA?
Well, the Scientific Working Group on DNA Analysis is a group of individuals from many different forensic laboratories across the United States and also internationally that are devoted to discussing current topics in DNA and setting guidelines, as well as managing the quality assurance standards for forensic DNA testing laboratories and DNA database laboratories. And they meet twice a year, and they're responsible for issuing documents for forensic laboratories and database laboratories to use in their analysis.
Okay. And have you testified as an expert witness in serology and DNA in the past?
Yes, I have.
Where and how many times?
Since I've been with the FBI, I've provided testimony 18 times and have been qualified as an expert 18 times in the area of DNA and serology, and the federal court systems that I've been qualified in have been Washington, D.C., Albuquerque, New Mexico, Oklahoma, Kentucky, Louisiana, Michigan.
That be all across the country?
Yes, sir.
Okay.
Sorry.
All right. Your Honor, at this time, I would move Ms. Sebert to have her admitted as an expert in serology and DNA analysis.
The state absolutely agrees, Your Honor.
Ladies and gentlemen of the jury, the witness will be accepted as an expert witness in the area of DNA analysis and serology. You may proceed.
Thank you, sir. Now, Ms. Sebert, how were you initially involved in this case?
When I was working as a forensic DNA examiner in the DNA analysis unit, I was the individual assigned to this case when it was received at the FBI laboratory.
Okay. And did you issue a report on October 8th of 2008?
Yes, I did, and at this time, if it would be acceptable that I may refer to the notes that I brought with me today that I used in conducting my analyses.
You may.
Thank you, sir. I have the October 8th, 2008 report in front of me, sir.
Okay. Now, I'd like to take you section by section, if we can do that.
Okay.
To the relevant sections. Can you first tell the ladies and gentlemen of the jury what Q's and K's mean?
Sure. At the FBI laboratory, there is a process of assigning a Q letter or a K letter to items of evidence when they're submitted to the laboratory. And this helps to distinguish the location or where the item was collected from. So a Q specimen would be a specimen that was collected from a crime scene. It is something that's not known to a person. A known or a K sample would be a known blood sample, a known hair sample, and things that can be associated directly to an individual.
So if you took my DNA with a buccal swab, I would be K1 or K2 or K3, however number of items.
That's correct.
Okay. And if you collected an item off of the floor, that would be Q1, Q2, and so on.
Well, that would depend.
Okay.
Okay. If you were taking a known fiber sample from this floor, that would be considered a known representative sample, and that would be K. But let's say hypothetically if you had dropped a mask or a hat, and that was collected off of this floor, that would be a Q specimen.
Okay. Thanks for clearing that up. Now, were you given items having to deal with the car of a Pontiac Sunfire that belonged to Miss Casey Anthony?
Yes, sir.
Okay. What were you given exactly? And we'll start with, if we can, the first items on your report.
The items of evidence that were received at the laboratory were received into the lab under a cover of communication dated July 28, 2008. And simply a cover of communication just refers to an incoming letter which describes the facts of the case to the laboratory for processing.
I do have an objection that I might raise at the record to whether the items are in evidence, but perhaps counsel can clarify where we're going with this.
I'm questioning the witness what work she's done on this case.
Right, but to testify about matters that are not in evidence, obviously that's a predicate, and I thought if counsel could clarify for us, maybe we wouldn't have a problem with it.
Okay.
These are items that are in evidence.
If I could just ask.
Now, let's approach the sidebar, folks. Okay, ladies and gentlemen of the jury, there are going to be some matters we're going to need to take up outside of your presence. We're going to recess to 10 minutes past the hour of 10. I'm going to ask you not to discuss this case among yourselves. This would probably be a good time to take a special break. Any additional instructions on behalf of the state or the defense? Okay, we'll be in recess. You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney, both sides ready to proceed.
Yes, sir. State's ready, sir.
Okay, y'all got everything straight now?
Yes, sir. We identified the exhibits, or we'll have just an agreement as to what they are.
Okay. All right, let's return to jury. State recognized presence of jury.
Yes, sir.
Defense,
Yes, sir, we do.
you may continue.
Thank you. Ms. Sebert, we left off talking about some items that you were given to test, and I'd like to take you through those items. First, I'll refer to Q from your report, Q13 and 14, which has been identified as State's Exhibit IJ. Can you look at that item, or can you look at your notes and tell the ladies and gentlemen of the jury what you did?
Yes. The two items, Q13 and Q14, and I apologize, I didn't hear the state's exhibit number. IJ, were identified as swabs from spare tire cover collected from the vehicle, tag number G63XV.
If I may, I'm sorry. I think that those probably need to be formally moved into evidence by the defense, to which I have no objection before the witness testifies about the analysis.
Okay. There being no objections lodged by the state of Florida. Huh? No, these are me. You wanted, it was marked for ID by whom?
By the state, but we'll move it into evidence. That's fine.
That would be defense exhibit.
Right, be defense exhibit. They're moving it.
Yes, sir.
Yeah. Okay.
Thank you, sir. Okay. When you have Defense Exhibit 13, when you have that, what's the first thing you did with those items?
So each of those items were looked at independently. So the first item, the Q13 swab from the spare tire cover, was examined in the laboratory, and a chemical test was actually performed on a portion of that swab.
Let me stop you there if I can. Okay. When you inspect it, you're in a laboratory, correct?
It is performed in a laboratory setting, performed by a biologist of the DNA analysis unit.
Okay. And what is the first thing done? The test that you're referring to, the phenolphthalein test, correct?
Correct. It's a chemical test, which is a test that will detect the possible presence of blood, and it is the official name is called by is the phenolphthalein test. Correct.
Okay. And what were the results of that test?
On each of those swabs, the test for the presence of blood was negative.
Now, I'd like to take you and direct your attention to the second page of your report on items Q22, which has been entered into evidence as States 143.
On those items, Q23, which was identified as a piece of spare tire cover, a chemical test was also performed on that item for the presence of blood, and it was negative.
Okay. And then after that, with that item, what did you do?
After that item, the testing was conducted on that item. It would have been repackaged up, and then the next item would have been opened up and also tested as well, and that item would have been Q23.
And that is, for the record, States Evidence 139. And what did you do with that item?
And that item was identified as a spare tire cover, and on that particular item, there were brown and yellowish stains that were observed, and those stains would have been tested using a cotton tip swab from the laboratory. So distilled water was placed on that swab, and those areas were actually then individually swabbed, and then the chemical test was performed on each of those swabs from each of those stains that were observed, and those were all negative for the presence of blood.
Okay. Now, when we are talking about spare tire cover, that's a round, circle, cardboard type carpet material?
Correct. A particle board type backing. Correct.
Okay. And then can you tell the ladies and gentlemen of the jury what the next item is?
The next item that was examined was Q24, and that was identified as the left side of trunk liner.
Okay.
It was,
just for the record, that's States Evidence 139. Okay. First describe the item to the ladies and gentlemen of the jury so they kind of have an idea of what you're talking about.
States Exhibit 139, or my item number Q24, was a dark gray carpeted section with a multicolored fabric backing on it. And then on that item, again, brown and yellow areas were looked at throughout, and those areas were swabbed and tested for the presence of blood, and they were negative.
Okay. And then what's the next item?
Q25.
And what is that described in your report as?
Q25 is the right side of the trunk liner.
Okay, and that, for the record, is States Evidence 140. Tell the ladies and gentlemen of the jury what you did there.
On that item, it was another section of a dark gray carpeted section with the multicolored backing, and brown and yellow areas were identified throughout as possible stains. And a cotton tip swab was taken, water was applied, and those brown and yellow stains throughout were swabbed, and then the chemical test was performed on it for detecting whether or not blood was there. And all of those stains were negative for the presence of blood.
Okay. So you had the spare tire well, correct?
Yes, sir.
The left side of the trunk liner and the right side of the trunk liner.
Yes, sir.
And you tested all of those areas for blood.
Objection has to answer.
Overruled.
Yes, sir. All of those items were tested and were negative.
Okay. What did you do with the swabs that you took from those items after you tested the area for blood?
After a swab is taken and the chemical test is performed on that swab is not retained by the laboratory. The chemical test has been performed. The period to see if a color change is going to take place or not has been observed, and that swab is not retained.
Okay. Did you do any other tests on those items?
Yes, sir.
Okay. Can you tell the ladies and gentlemen of the jury what kind of tests you did after that?
Yes. On those particular items, again, I'm referring to my notes.
Sure.
on specimen Q22, which was the piece of the spare tire cover, Q23, the spare tire cover, Q24, the left side of the trunk liner, Q25, the right side of the trunk liner. A swab was taken of those items and processed for DNA typing.
Okay. And what were the results of the DNA typing for the trunk of the car items that you described?
There was no DNA profile generated from those items.
Okay. Now, just so the ladies and gentlemen of the jury can understand a little more about what you do, the phenolphthalein test the chemical test that you did, that was for blood, correct?
That's correct.
Is it fair to say that the reason you took it a step further was because there are more types of bodily fluids that you could pick up with DNA that you can't from that chemical test?
Objection leading.
Sustained. Phrase the question.
Why
Why do you do the DNA test?
Well, although the chemical test for the presence of blood was negative, the next step was to determine were there any other type of biological cellular material that could be detected through swabbing and a DNA result generated from that. So from any cellular material that could be present, or if there were any other types of stains that were there that weren't necessarily observed that could have contained DNA material.
And what can you get DNA from in a person's?
Every cell of your body except your red blood cells. They don't contain a nucleus. So any type of cell that has a nucleus is where the DNA is housed. So skin cells, white blood cells, the tissue, if you yank out a piece of hair, the tissue that's contained in there. And all of those cells within the nucleus contain the DNA. And that DNA is the same in all of your cells.
Okay. All right. Now, on further down on page 2 of your report, you received. Can you describe to the ladies and gentlemen of the jury what the items are from Q33 to Q43? And just for the court, the state and the defense have a stipulation with no objection on these description of these items.
Counselor, just remind me which item those are.
The clothing.
The clothing. No objection.
Okay.
I believe the agreement is that those are the items referred to by Investigator Bloise as being clothing from the Anthony home.
Thank you, gentlemen.
Thank you. You received some items from closet of East Room at 4937 Hope Spring Drive, correct?
That's correct.
Okay. Can you tell the ladies and gentlemen of the jury what you did with Q33 and so on?
Yes, so the items that were submitted from the closet, there were several different particular items, and I'll start with the first one, which was Q33, which was identified as a pair of pants. They were dark gray color, and that item was visually examined for the presence of any biological stains, and none were observed. So in that case, on that particular item, there was no chemical testing performed.
Okay. And what about Q34?
Q34 was identified also as a pair of pants, and they were actually light blue pants in color, and that item had some faint brown, yellowish brown spots contained on those pants, which were tested for the presence of blood and tested negative for the presence of blood.
Okay. And Q35?
Q35 was identified as a pair of pants. They were a pair of blue jeans, and a visual examination was performed on that item, and no biological stains were observed, and therefore no chemical testing was performed on that item.
Okay. Q36?
Q36 was identified as a skirt. It was a light gray skirt and had some very faint yellow type stains contained on that skirt, which were tested for the presence of blood and tested negative.
And Q37?
Q37 was identified as a skirt, and it was a light yellow skirt, and there were faint red spots throughout, primarily on the outside, the front left, and those were negative for the presence of blood.
And Q38?
Q38 was identified as a skirt. It was a light beige skirt and had faint yellow areas contained on it, and those areas were tested and were negative for the presence of blood.
Q40? I'm sorry, did I skip 39?
Correct. There's Q39. Q39 was identified as a shirt. It was a light blue button-down long sleeve collared shirt, and it had some faint discolorations contained on the left breast pocket, and those areas were tested and were negative for the presence of blood.
And Q40?
Q40 was identified as a shirt. It was a light beige button-down three-quarter sleeve collared shirt, and there were some faint areas of discoloration on the outside front lower right, which were tested for the presence of blood and were negative.
Q41?
Q41 was identified as a shirt. It was a bright pink sleeveless turtleneck shirt, and that area was visually examined for any biological stains. There were none observed, so chemical testing was not performed on that item.
Q42?
Q42 was identified as a shirt. It was a light pink button-down three-quarter sleeve collared shirt. A visual examination was performed on that item, and there were no stains observed, and therefore no chemical testing was performed.
Okay. And Q43?
Q43 was identified as a shirt. It was a green button-down three-quarter sleeved collar shirt, and a visual examination was performed on it. There were no biological stains observed, and therefore no chemical testing was performed on that item for blood.
Was there any blood on any of the clothing that you received from the Anthony home?
No, sir, not on those items.
Did you receive any other clothing that's not in this report that you tested?
From the home?
Yes.
No, sir.
Okay, I'd now like to take you to the next item that you tested, Q44, which is State's Evidence 323. Can you tell the ladies and gentlemen of the jury what that is?
Yes, sir. Q44 was a piece of the spare tire covered, and it was a gray carpet cutting. And Q45 was a piece of spare tire cover as well, and it was also a gray carpet cutting.
Okay. And Q44, what did you do with that item?
That item had some extremely faint brown dingy areas on it that were spot tested for the presence of blood, and they were negative for the presence of blood.
Did you do anything beyond that?
On that particular item, it was actually combined with the next item for DNA testing.
Okay. Let's go to Q45, which is State's Evidence 142.
On Q45, there were extremely faint brown dingy areas on that item that were spot tested, or were tested for the presence of blood, and they tested negative as well.
Now, tell the ladies and gentlemen of the jury what you did with both of these items together after you tested them for blood.
On those two items, a swabbing was taken, just a regular cotton tip swab with water applied to it, and a swabbing was taken of the entire item, as well as the Q45 item, and those two swabs were combined and processed for DNA.
Okay. And can you tell the ladies and gentlemen of the jury what the results were?
There were no DNA typing results obtained from either of those items, and they were combined, so there was essentially no DNA as a result.
Okay. I'd now like to direct your attention to the report that you issued on October 9th, 2008. Just let me know when you have it.
I have that report in front of me.
Okay. Ms. Sebert, can you tell the ladies and gentlemen of the jury what item we're discussing, and a description of it and the Q number.
From the October 9, 2008 report, the items of evidence that were examined were Q46, which was identified as a shovel, and Q46.1, which was a label from the Q46 shovel blade.
Okay. And for the record and court, stipulation that we could describe these items without any objection.
These are the items testified to by Brian Berner, the shovel testified to by Mr. Berner earlier in the case.
Yes,
we do agree. Thank you.
Okay. And could you tell the ladies and gentlemen of the jury what you did with the shovel?
Yes. The shovel was examined for the presence of blood, and so visual examination was performed on that to identify if there were any possible stains. There were some areas that were, in fact, tested on the shovel, and those areas were negative for the presence of blood.
Now, I'd like to direct your attention to your report of December 16th, 2008. I know you issued two, but I'll let you know which one specifically.
Before we leave this report, I wanted just to be sure the testing that we discussed was the specific to the serology, but there was also DNA performed on that. So I just wanted to be clear on that.
Okay.
With that.
And what were the results of the DNA?
A DNA profile was not generated. There was a sex typing result at the amylogenin locus or the location, but it did not satisfy the reporting criteria of my laboratory.
Okay. And just so we can explain that a little bit, when someone grabs and touches an item, DNA is left, correct?
It's possible.
Okay. But would the touching of how much DNA you recover depend on the item, how much force is used, and other factors? Can you tell the jury a little bit about that?
Objection, leading and compound question.
Sustain, rephrase the question.
Can you describe to the ladies and gentlemen of the jury a little bit about touch DNA?
Well, touch DNA refers to...
Let me object to the relevance since she indicated there was no profile found. I don't know the relevance of this explanation.
I think it goes through.
Well, touch DNA refers to a type of DNA testing where you expect to have very limited amounts of DNA left behind. It's on items that may not have had a lot of contact with an individual, such as perhaps a piece of paper. If you pick up a piece of paper and you hold that piece of paper in your hand for a little bit of time, it's possible that you've deposited some type of cellular material from your hand on that piece of paper. But in order to get a DNA result that is typable or usable depends on lots of factors. How long you perhaps had that in contact, and if you are capable of leaving a lot of skin cells behind. And so that all comes into play when you're looking at a DNA result when we're talking about samples that have had limited contact.
Now, when we talk about levels of DNA, how is that measured?
Not sure I understand your question.
What are RFUs?
RFUs talk about relative fluorescent units.
To the relevance that we approach.
You may. objection, overruled. You may continue.
Okay, Ms. Sebert, you've already described to the ladies and gentlemen of the jury of what touch DNA is, correct?
Yes.
What is low copy number DNA?
Members of the jury, can you use bias?
Yes.
Okay. Thank you.
Actually, if I can help. Sure. Thank you.
You better take it off until he gets it adjusted.
Okay. Can you hear me? Can everyone hear me much better? All right. Ms. Sebert, I'm sorry. Can you explain low copy number DNA?
So low copy number DNA is a type of DNA process where going into performing the DNA testing on it, the individual knows there's going to be a limited amount of DNA information there. And so there is a procedure that can be performed to enhance the DNA analysis process to make even more copies, which we haven't really talked about, in the PCR process. So it's actually adding on some of the molecular xeroxing during the polymerase chain reaction when you're actually making multiple copies of DNA to enhance the end result, the DNA profile. So going in, you know you're going to have a limited amount of DNA, and so you're actually enhancing your DNA analysis process to adjust for that, to make more copies to generate a result. And with that result, there's certain evaluations that have to go into those results because of the nature of low copy number. Since you don't have a tremendous amount of cellular material at the beginning, there are some things that in the end that have to be evaluated in order to generate the reliable or to have a reliable result.
Okay. So when we say low copy number DNA, I know these two terms are used interchangeably at times, but that's incorrect, right?
That's incorrect.
Okay.
Right. Touch DNA can be samples where at our laboratory, if a firearm comes in, and you think about the nature of when you hold a firearm and you put your finger on the trigger, your hand on the grip, you're coming into contact with it, but not necessarily for maybe an extended period of time. So that would be an area that we would swab, knowing that that's where an individual's had contact. I would expect perhaps to get a result for the deposit of skin cells, but I'm not going to enhance my technique to make more of those copies from my normal analysis procedures. I already expect to have limited amounts, but at the current, when I was in the unit, we didn't have procedures to perform low copy number, which is enhancing the analysis techniques.
Now, I want to skip ahead a little bit to when you actually get the readouts of the DNA results. Can you touch briefly on that? Because I don't want to get too technical.
So what the end readout or the profile is.
Correct.
Okay. Can I back up even a little bit more just to talk about the DNA process?
Sure.
Okay. Since we haven't talked about it, the actual DNA process, how that occurs is, let's talk about a swab. We've talked about doing a swabbing of the carpet out of the trunk, the spare tire cover. So that swab is put into a tube, and there are chemicals that are added Because in order to do DNA typing, we have to get to the nucleus of the cell where all the DNA is housed. So those cells have to be broken open in order to really get to that DNA and unwrap it from where it's contained within the nucleus. And so we're able to do that by adding chemicals, and then that DNA is now taken through the process. And the next step after we're able to extract that DNA away from the item that it's contained on is what's called the polymerase chain reaction, the PCR. And what that is essentially a molecular Xeroxing. It's like going to a copy machine and making billions of copies of that one page that you have, that you need copies of, but we're actually doing that at multiple locations on the DNA. We're actually looking at 13 locations on your DNA, and so we're taking all of those 13 locations and making multiple copies of the DNA that's present. And so the next step then is to actually, utilizing an instrument, the DNA is put into a capillary column through a process called capillary electrophoresis. And this instrument has a very small capillary column where the DNA in that liquid form is injected into this capillary column, and we're able to detect it through a process using a laser. And we talked about those RFUs, or those relative fluorescent units. What that's telling me is it's signaling that there's DNA present. And it's able to send that signal to a computer, which is collecting all of that information, and then it's interpreted into a DNA profile. Much like if you've been to the doctor and you have a heart monitor set up and you get an EKG done, you see those peaks on the EKG machine. That's what essentially my end product looks like, those peaks. And those are representative of the DNA profile from that initial test tube where we extracted the DNA out and we were able to remove it from the inside the nucleus of the cell, and now I'm able to see the end result and generated a DNA profile, which I now will use in my interpretation.
Okay. And what you get through your readout, which are called electropherograms, correct?
That's correct.
Okay. And what you get are some squiggly lines and some peaks, do you not? Among other things.
Yes, the peaks are what I'm most interested in.
Right. Okay. And what you talked about to the ladies and gentlemen of the jury are the 13 different locations of where you search for DNA, correct?
Correct, the 13 locations, yes.
And these are also identified as markers.
Correct.
Okay, points of interest, so to speak.
Correct.
Okay. And depending on how much DNA there is there, well, the peaks also indicate to you how much DNA is present at that specific marker, correct?
Correct. The RFU units will be higher depending upon the amount of signal that's being sent to tell the instrument that it's detecting the DNA that's passing by that laser and creating a fluorescence, which is being collected and is outputted into a peak.
Okay. So if you have, what are the cutoff levels for your laboratory when reporting out something as DNA being at that specific location?
To actually report a DNA type, the threshold for my laboratory at the time I was in the unit was at 200 RFUs. And that was our match interpretation threshold. So anything above 200 I could use to make a match with.
Okay. And there are other laboratories and other kits that can actually report lower levels, correct? That's just that 200 for you to report.
Overall, she can ask the question.
For you, that 200 level number, it's a determination made by your laboratory.
Right. That number was based on the validation by the FBI laboratory at the time when we were validating the instrument and the kit to do the DNA typing in the unit.
But it is common in other laboratories that sometimes the threshold can be lower. Is that correct?
Overall.
Other laboratories will have different interpretation thresholds. That is correct.
Okay. And can you explain to the ladies and gentlemen of the jury as to what your threshold is to exclude an individual?
Any information that falls below that 200 RFU interpretation threshold can be used for exclusionary purposes. But there is one more threshold that's not depicted on your chart.
Okay, and what is that?
That is at 50 RFUs.
Okay, and what does your threshold with 50 RFUs mean?
50 RFUs is the threshold for where a peak will be labeled a peak. That is our peak amplitude threshold, which is based upon the validation of where a peak will begin to be detected in the FBI laboratory.
Okay. Basically, some people will call these other items down here noise or artifacts.
There are other laboratories that may in fact use the threshold below that 50.
Okay. And if in your laboratory, if you see something that's 50, you can call it a peak.
That's correct. That is when the threshold for identify or labeling a peak begins.
And would you consider the laboratory thresholds that the FBI uses as conservative?
The 200 RFU threshold it's a relatively conservative threshold, yes.
Okay. And the 50?
Conservative. It's based on the validation, so I would say that is a scientific threshold based upon the validation for when reliable results are generated.
Okay. Now you told the ladies and gentlemen of the jury about you being able to call something at the level of 50 a peak, correct?
Correct.
Now, and that would give you an indication that there's something there, correct?
At 50?
Yes, at 50.
Correct.
But unless it reaches 200, you can't report it out.
If it is at the STR loci, cannot be used for inclusion unless it is above 200. There's an exception with the amylogenin or the sex typing locus where information can be used if it's below 200.
And to kind of bring it all together with what we talked about with the shovel and some other items that we're going to talk about, when you say that you cannot report it, doesn't mean that there isn't some DNA there. It's just something that your protocols preclude you from making or giving an opinion on, correct?
Objection. Based on the conversation with counsel. With the court.
Okay, you can approach.
No, I say based on the court's earlier ruling. All right, we'll approach.
Yeah. Okay, members of the jury, there's going to be a brief legal matter we need to take up outside of your presence. I'm going to ask that you step outside. We will get back with you as quickly as possible. You may be seated. Okay, the jury is outside of the presence of the courtroom. You may proceed with the proffer.
Ms. Sebert, the amylogenin peak that was derived from the shovel, can you give us the RFU for that?
Certainly. On the swabbing from the shovel at the amylogenin locus, there was an X for the female that appeared at 55 RFUs.
Thank you. I think that answers our question, Your Honor.
Yes.
The import of that then would be to
Exclude it as being from a man, but not identify it as a woman. Is that how that would be interpreted?
Well, it's at such a limited amount, I wouldn't be able to give any type of information pertaining to that.
Oh, so you can't draw any conclusions?
I cannot draw any conclusions from that limited information.
Judge, that would be my objection. It's a result from which scientifically no reliable conclusion can be drawn. Therefore, it would not be admissible. To tell the jury this and to ask them to somehow interpret it in some way different than the witness does would, I think, be improper.
If I may briefly respond, Judge, I'm not asking her to report the results or to identify that it came from a female. I believe the witness has already testified that if it reaches the 50 threshold, that is an indication that there is something there, that it is beyond an artifact. That is all that I am attempting to elicit from the witness. Nothing more, nothing less.
The question, what's the relevance of that? What difference does it make if there is something there that cannot be scientifically interpreted to mean anything? Then what is the relevance of it?
The relevance is that there is DNA there. Not sufficient enough for her to make a determination as to who it belongs to or what it is, but there is something there. And that is it. Nothing more. Now, there's a huge difference between being able to report something, exclusion or inclusion. We're not discussing that. We're discussing whether DNA material, and the witness has already testified that if it passes the 50 threshold, that is an indication that there's something there. That's it. As far as now, if that is fair game for cross-examination, when Mr. Ashton wants to get up and say, you can't say this, you can't say that, you can't do this, and that's fine. But as far as what I'm trying to elicit from the witness is simply that there was a portion of DNA there, and that's it, nothing more.
The problem is, to what end? Is counsel going to elicit this and then at some later point argue to the jury that somehow that bit of DNA could have been amplified, could have been this, could have been that, without scientific support? Unless it is relevant to an issue, then it's meaningless. It's not relevant.
If it's not relevant, why is the shovel in evidence?
Judge, the shovel is in evidence.
Mr. Ashton, calm down.
Sir.
Okay? Calm down. Sit down for a second.
Yes, sir.
Okay. Have you finished, Mr. Baez?
Well, my point is, Judge, this shovel has been brought into evidence. It is a relevant piece of evidence. There's testimony been admitted that Miss Anthony borrowed the shovel.
I'm not concerned. I'm concerned about her testimony and what she's going to say. Okay. You have anything else to say about her testimony?
Nothing further, sir.
Okay. Mr. Ashton, reply from the state of Florida.
Yes, sir. I still would submit that the fact that there is a scientifically meaningless result on a test isn't relevant unless it can be tied into some issue in the case. And my concern is that counsel is going to, without eliciting from a witness whether this could ever be used to do anything, argue to the jury something that we know is scientifically incorrect. I think it needs to be relevant for some argument or some issue before the court.
The converse to that, Mr. Ashton, is those are things that you can ask her in your cross-examination. Ma'am, the results that Mr. Baez is seeking to elicit from you, exactly what does those results mean?
All I can tell you, Your Honor, is that there is a peak there, and it is...
Is it DNA?
Considering that the initial threshold of determining a peak is at 50, and that peak does appear above 50 RFUs, it is a peak and is consistent with an X at the amylogenin typing, or at the locus. So I have no other information other than there is a peak.
There's a peak, and it is an X, you said?
Yes, sir.
Okay, and what does that translate into?
Well, it potentially could be from a female, it could be from a male. It's at such a low level in my report for the conclusion that I gave is that it is, do not satisfy the reporting criteria, and no conclusion can be offered.
So you can't say whether it originated from a male or a female?
Well, with the absence of a Y peak, all I can tell you is there's an X there.
And you can draw absolutely no conclusions from that?
No, sir.
Okay.
I'm not asking for any conclusions of the witness, nor will I ascertain. The only thing that I was attempting
Okay, let me cut both of you short. Okay. I will permit you to ask the question. The state can clear it up in cross-examination, and then the jury can take it for whatever it's worth. Okay?
Yes, sir.
Anything else, folks?
Your Honor, may I ask a question?
Yes, ma'am.
And I don't know how the information will be presented, but it is at a level that, since it's not in my report, I would have to be speaking about the result from a table that's in my report if we're going to address that. That's in my case file to address that specific piece of information.
Okay. Anything else, folks?
Nothing further.
Okay. Let's return to jury. Okay, state recognized presence of jury. Yes, sir. Defense?
Yes, sir, we do.
Okay, Mr. Baez, you may proceed.
1, 2. Can everyone hear me? Okay. Ms. Sebert, where we left off, and I'm just going to recap for a moment before I ask you my next question, is we talked about the different thresholds of how much DNA is present on your electropharograms, the readouts. And when we were talking about the shovel, you mentioned that at one of the markers there was something that reached above the 50 RFU levels. Is that not correct?
Correct.
Okay. It did not reach the 200 level, and you did not have multiple markers or sufficient markers to be able to report it out, correct?
That's correct.
So is a fair statement that there is something there, you just can't report what with any degree of scientific certainty?
Sustained, rephrase the question.
What's the best way to summarize what's there and what's not there?
Well, at the locations that the short tandem repeats would be present at, the 13 locations, the DNA profile, a result was not obtained at any of those 13 locations. For the amylogenin or the sex typing locus, which would indicate male-female DNA, there is a indication present of DNA at that location, but it does not meet my reporting criteria.
Perfect. Okay. Now I'd like to direct your attention to the next report that you issued in this case on March 19th, 2008. I'm sorry, that would be 2009. And let me know when you take your time. Just let me know. I know you got a lot of stuff there.
You may.
I have that report in front of me, the March 19th.
Hold on.
I'm sorry.
You may proceed.
Have you had sufficient time to get your documents?
Yes, sorry about that.
And you have your March 19th, 2009 report?
Yes, sir.
Okay, can you explain to the ladies and gentlemen of the jury what these items of evidence were?
The items that were reported out on the March 19, 2009 report were identified as Q62 through Q64 as tape, which were items from the medical examiner's office.
And for the record, this is State's Evidence 302. And are we talking about duct tape?
Yes, sir.
Okay, and these were duct tape items that you received from the medical examiner's office?
Yes, they were submitted to the FBI laboratory, and the origination of where they were collected from was identified from the medical examiner's office.
Okay. Can you explain to the ladies and gentlemen of the jury what you did?
On the items of the tape, they were examined, and there were 3 pieces, Q62, Q63, and Q64, and that the first examination was done on the top side of the tape. I'll refer to it as the silver side of the tape. And a cotton tip swab was taken, moistened with water, and the top side of that silver area was swabbed to collect any possible biological material that would be present on that silver side of the tape.
Okay. And when you say the top side, you're talking about the non-adhesive side?
That's correct, the top side, yes.
Okay. And were there any distinct markings on the top side of the tape to help you identify the item of evidence?
I have a description here that the manufacturer's logo, Henkel, spelled Henkel, was throughout the tape.
Okay. And did you get any results, any DNA results from the top side of the tape?
Yes, so the swab itself, DNA typing was performed on that swab that was collected from those 3 areas of tape, and a DNA profile was generated. However, it was below the interpretational threshold of the FBI laboratory's reporting policy.
Okay. And when you say below the threshold reporting policy, can you give us how many markers were present, number 1?
On the top side of the duct tape, or the silver side of the duct tape, an STR result, or the DNA typing result, was obtained at 6 of the out of the 9 locations that were tested. And if I can just back up and describe that
Sure, please do.
For you. So in doing DNA typing, there's actually 2 typing kits. They're called amplification kits that are utilized to come up with the totality of the 13 locations.
Let me ask you, I'm sorry, Ms. Sebert, would it assist you to would it assist you to use the board to kind of explain it a little clearer, or do you feel comfortable enough doing it from the stand?
As long, if it becomes confusing, you can let me know.
I don't know if the jurors can let you know. Well, Your Honor, may the jurors raise their hand if they're getting a little confused on the issue?
No.
I can list out the locations if that would be helpful.
That might be a little helpful. May the witness stand down, Your Honor?
Yes.
Okay. I can hold your papers if you like. Okay, sure.
Okay. So the areas that we've kind of talked about, there are 13 locations on the DNA, and they are selected because of their highly polymorphic, or they're very different between individuals. And they're actually located on different chromosomes. And we haven't talked about chromosomes, but you actually have 46. 23 of them came from your mother, 23 of them came from your father. And so on those chromosomes, certain locations have been identified as being highly polymorphic or different, that have been selected to be looked at in forensic DNA typing. And so within one of the kits, there are actually 9 of those locations that have been identified and that we will amplify the DNA with, or target those locations, make the copies, and generate, if there's enough DNA there, a DNA result. And so I'm going to write out those DNA locations for you so you can see their names, and I can tell you a little bit about what each of those names means.
We might need to put this a little closer. Can you see that, Mr. Ash?
I cannot see that. You can just push back just a bit. Yeah, that's fine. Right where you had it was fine.
Right there?
I can't see it.
Can everyone see it? Okay.
So what I've listed out here are each of, well, this is 9 of the locations that we would look at in one of the tests, or that are contained with one of the kits. And that kit that I've listed here is the Profiler Plus ID kit. And each of these locations, this one is D3S1358. D3 is actually on chromosome number 3, and it is the location. It's basically like its house address on the chromosome. If you think of the street that you live on, it's the main street, and it's kind of like the house number for the area that's been targeted. And so as you go down the line, you have VWA, FGA, D8S1179, D21, I'll shorten them, D18, D5, D13, D7, and then amylogenin, which we've been talking about as the sex typing locus, which will tell whether or not you have male or female DNA present. And so what happens during the DNA typing at the very end, as a part of my analysis, when I do my interpretation, I'm actually looking at the peaks that Mr. Bias talked about earlier at each of these locations. So at D3, I would actually look at if there are peaks present and what the DNA type is for each of those peaks, and then I would populate the table, which would represent the DNA profile. And what these peaks actually represent, and we've talked about, is DNA, but these are actually the short tandem repeats. They're STRs, which are the types of DNA repeats that are present at each of these locations. And so essentially counting up how many of those repeats are present at each of the locations that were examined.
And do you get one of those numbers from your mother and one from your father?
That's correct.
Okay. And what happens if both of your parents have the same one at that location?
So if your parents have the same STR type at that location, then you're going to have just the one peak. So for example, let's say if we'll call this D3 here, and let's say this is a 15, 16, and let's say we go to VWA, and there's just one peak there. That means both your mother and father have given you that one type, and then you would just be, we'll call it a 10. And so both parents have given you that 10 as part of your DNA makeup at that location.
So what we've looked at so far that you've written, in a hypothetical situation, this person would be a 15, 16 at this marker, and then a 10 at this marker.
Sure, and that's, yeah. So each of these markers, there will be if there's enough DNA present to generate a result, there will be a peak or 2 peaks present if you have a single source sample.
And when you have the full combination of the 13, that is when you have a DNA profile.
Well, you can actually have a DNA profile just at one location. So you don't necessarily need all 13 to have a DNA result. It could just be at one locus, it could be at two, it could be at a combination of them. And so I've only listed out 9 of the locations here. The second test actually has another series of these locations contained within it that are targeted. And that's where you get the additional loci would be in the next test or locations.
And depending on the marker, it tells you how discriminatory it is, meaning how many people might have that number at that location?
That's actually a different part of the process.
And I know we're kind of jumping ahead, but as it relates to the duct tape, what did you find on the non-sticky side of the tape?
In my report, I identified that there was an STR typing result obtained, but it fell below my reporting threshold. So if I list that profile here, it's going to, if I can list it as such that it would be representative of a profile that I would only be, that would fall below my reporting threshold. Okay. If I can write it out that way, but indicate that.
Okay, that's fine. That's fine. We understand.
Okay. Sorry about that.
Now, how many of these markers do you need to exclude someone?
It could just take one marker to exclude an individual.
Okay. In what you obtained, could you exclude Casey Anthony?
Now we're talking specifically to this particular item.
Correct.
Yes.
Okay. So Casey Anthony was excluded from what you got so far?
Yes.
Okay. And was Kaylee Anthony excluded as well?
Yes.
Okay. Did you do something further to try and determine who this partial profile belonged to?
Yes, I did.
Okay. What did you do?
Well, after I had generated this DNA profile, I used all of the known samples that were submitted to the laboratory, the known blood samples that were submitted from Ms. Casey Anthony, the known profile that we used for Kaylee Anthony, as well as other family members that had been submitted, Cindy Anthony, Lee Anthony, George Anthony, and I compared those profiles to this DNA profile that I had generated. And all of those individuals were excluded from this profile.
Okay. Did you take it a step further? Actually, we could probably get you back to the witness stand.
Thank you.
Take that from you so I can give it to Steve. What was the next step that you took to try and determine who this might be?
Well, based upon the generation of that profile in it, and I had excluded the known samples that had been submitted as a part of this case submission, the next step was to evaluate the staff database that was maintained of the DNA analysis unit. So the individuals who work in the DNA analysis unit will provide a sample and will maintain a database of all of those types to compare when a profile is generated to determine if it could be one of the staff who would work the case or who are working in the laboratory.
Okay. And did you find someone that matched all of these different markers?
Not, and they're not from the DNA analysis staff database. No, I did not.
Okay. What did you do to, what further did you do?
The next step that I did was I determined what other units at the FBI laboratory had processed this item of evidence, and knowing that the profile I had was a female profile, I started looking at specifically any female female examiners or technicians that would have handled this item. And so working with the evidence control unit, I was able to identify which units this item had been processed in, and I contacted those individuals and asked if they would give a DNA sample.
And did they?
Yes, they all did.
Okay. And who did it turn out to be?
This profile was matched to Lori Goddman, the question document unit's examiner.
Okay. Now, this is, well, let me ask you this first. Is it possible when you contaminate DNA that it may overwrite DNA that's already there?
Well, it would depend on the quantity of the DNA that you're suggesting is the contaminant. So there would be some factors that would have to be considered with that.
Okay. Explain those factors.
Well, depending on the quantity of DNA, if you have a very large quantity of DNA, it is possible that it could shadow or hide the very small presence of DNA from another individual. However, on this specific item, the profile itself is at low levels, and so if there had been an additional individual present, I would have expected to see a mixture at some of those locations.
But that would only include if you had various, a large enough amount of DNA to account at different markers, correct? Meaning if you only had 2 markers and this DNA overrode that, or just one, it is certainly possible that this would overshadow any DNA.
Objection. It assumes hypotheticals, not based on facts and evidence in this case.
Sustain, rephrase the question.
Yes. If it's still possible that this contaminant could have contaminated other DNA that's there, correct? At lower levels?
I would have expected at the levels that this profile is at, if there was an additional profile there, I would have expected it would have been mixed with another profile if contained there.
And what if that profile that might be there would be at such a low level that it got overridden with this? Is it still possible?
Objection. Hypothetical, not based on facts and evidence.
I'm asking her a scientific question, Your Honor. She can answer it.
Hypothetical that's based upon facts that are not in evidence, and I would submit improper.
I don't think, Your Honor.
Yeah.
Okay, let me ask you this. Can contaminating DNA override something that's already there?
Objection. Asked and answered.
Overrule, I'll let her answer the question.
This is a hypothetical. If you contaminate an item, can it override DNA that's already there?
If the presence of a very large, if you have a very large volume or percentage of DNA deposited on an item in a very small amount of a second individual, it's possible.
Okay. Now, the item of evidence got to the DNA lab, much later through the processing of this duct tape, did it not?
We were the last units, yes.
Okay. Is that common?
Not sure how to answer your question if it's common.
Sure. Would it have been more advantageous for DNA to get the duct tape first, the DNA lab to get the duct tape first before other technicians had already had access to it and potentially contaminated it?
It wouldn't have altered the way that the tape would have been processed in my unit.
Okay. But it would have reduced the possibility of other people contaminating the duct tape.
Well, any time an item is handled by fewer people, there's a less of a chance of another or of individuals' types being deposited on that item. So sure, the fewer people that handle an item, the less chance there is of a contaminant or another DNA profile being deposited on it. But that still didn't change the way that I would have processed that item.
I understand, ma'am. From your understanding, how many divisions and people got to this duct tape and processed it before you got it?
Well, the examination plan is developed by the evidence control unit for the movement of items in the laboratory, and that's where the decision is made for the movement of items in a case. And so on this particular item, there were several different types of examinations that were going to be performed. So it went through the trace evidence unit, the chemistry unit, latent print unit, and the question document unit prior to the DNA analysis unit receiving it.
Okay. Now, it was your understanding as well that the duct tape had been exposed to numerous elements, right?
The case information did describe that the location of where the evidence was collected from was outside and would be have water in it at times, and so yeah, so it was conveyed in the incoming letter that it was outdoors.
Now, the elements do and can degrade DNA, does it not?
Overall.
Sure, the elements, sunlight can destroy or deteriorate the DNA that's present, humidity, those several different factors of being outside could impact the amount of DNA that would be left on an item.
So why do you then do the tests?
Well, based on the item itself as being evidence in this case, it was my thought that from a forensic standpoint, the item should be swabbed to determine if there was any DNA present on that tape that was left on the victim.
Okay. And you can still get DNA even from items that are underwater?
Objection.
Can you not?
Sorry, I thought it was objection leading.
Question calls for a yes or no answer. Chance, can you get DNA from an item that's underwater?
I don't believe that was the question as phrased.
I believe it was, Judge.
And you still get DNA even from an item that's underwater?
Yes, sir, that's what I objected to leading.
Overruled. Can you answer the question, ma'am?
In a yes or no fashion, Judge?
It calls for a yes or no answer? Unless you need to explain.
If I could have the opportunity to explain.
Go ahead.
Okay, thank you, sir. It's possible, but there, again, would be several different factors that would be involved in the length of time an item has been submerged, what type of biological fluid, was it blood, is it semen, is it other types of biological fluid that were present on that item. So there are several factors that would be considered into whether or not you would be able to obtain a DNA profile from something that has been submerged underwater.
And in fact, you can also get DNA profiles from people who've been burnt victims, can you not?
Sustained.
Do you know if you can get a DNA profile from someone who has been burnt or a burnt victim?
Yes, sir, you can.
Okay. And are there multiple variables that could determine whether a DNA profile can be generated?
Sure, there are variables that the generation of a DNA profile would have to be considered. Sure.
Okay. And is it fair to say that you never know what all the variables are until you actually test it?
Objection leading.
Sustained, rephrase your question.
Yes, sir. Would you know what all the variables are of a specific item before you test it?
No, I don't have all the knowledge of an item prior to its coming to the FBI laboratory.
Okay. So Is it possible for you to know whether you'll get DNA from an item unless you actually test it?
Can I answer that outside the yes or no, sir? Well, that would depend. If it's a blood sample that is a red-brown stain, I expect to get a DNA profile from that reddish-brown stain that I've concluded is blood. If it is a general swabbing on an item that I've not identified any biological staining, but I'm trying to collect biological material, in that case, I don't know if I'm going to generate a DNA profile.
Okay. And when dealing with duct tape specifically, where would you expect to get a profile? Where would you expect to get a better chance of getting a profile? The outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Objection to a hypothetical applicable to this case because of the environmental factors. Could we
Please.
approach for just a moment?
Yes.
Thank you.
You may continue.
I'm sorry, I forgot where I left off. Can I ask the court reporter to read back where we were, Your Honor?
You may.
Question, when dealing with duct tape specifically, where would you expect to get a profile? Where would you expect to get a better chance of getting a profile, the outer portion for the person applying the tape, or the inner portion where it might be attached to someone's face, saliva, and other bodily fluids might be getting on it?
Can you answer that question, ma'am?
Yes.
Okay.
The higher likelihood of where the DNA profile would be generated from would be from the underside, where it's actually coming into contact with an individual's face, saliva is being deposited on it, so there's cellular material coming from from saliva.
And if it is attached in a violent manner, it would also have skin tissue attached to it, would it not?
I'm not sure that I understand the violent manner.
If it was put on firmly, tightly, that would have skin tissue on it, correct? Or you would expect to find skin tissue on it?
Well, just the contact from the tape being placed on on a person's face. You think about the adhesive, and just like when you pull a Band-Aid off, that hurts, and it's what it's taking with you are part of the cellular material on that topical surface of your skin. So you think about the same adhesive contained in a piece of duct tape being placed on the face, the same type of adhesive is taking place with the contact.
Okay. And did you test the adhesive side of the duct tape?
Yes, I did.
And was there anything that you were able to find there?
The information that was generated was inconclusive.
Were you able to find a was there a readout at a D3 marker?
There was a peak detected at the D3, yes.
Okay. And can you write down or tell us what number that peak came to?
Yes.
You can just say it.
Okay, it's a 17.
17. Do you know if Kaylee Anthony is a 17 at the D3 marker?
I'm going to take a moment just to retrieve my profiles. At D3, Kaylee Anthony is a 14-15.
Okay. So she does not have a 17 at that.
No, sir.
And if you had a 17 at a D3 marker and she is a 14-15, could you exclude Kaylee Anthony as being a contributor to that?
Yes, she does not have a 17 at that location.
Okay. And what about Casey Anthony?
Casey Anthony is a 14-15 at the D3 location.
Okay. So she also does not have a 17 at the D3 marker.
That's correct.
Okay. And when you have one marker that does not match an individual, can you exclude them from being a contributor to that DNA?
Yes.
Were you given the DNA profile of anyone else other than members of the Anthony family?
Yes, I was.
Okay. Who else were you given?
Are they in evidence?
No, they're not, Judge. I'll withdraw the question.
Okay, thank you.
Okay, I guess that's everything that concludes the March 19th report, correct?
Yes, sir.
Okay, let's move to your next report on July 24th, 2009. Just take your time. Let me know when you have it.
Can you repeat the date again, please?
Yes, July 24th, 2009. I believe that's from my draft, but you have it as August 19th of 2009.
Yes, thank you.
Okay. Can you identify to the ladies and gentlemen of the jury what items, the first item that you received on this report?
Yes, the first item that was received is identified as Q80, which was a pair of shorts.
Okay. And for the record, this is State's Evidence 269. And where did these shorts come from?
These shorts, the shorts were identified as items from the medical examiner office.
Okay. And what tests were done on those shorts?
On the Q80 shorts, the item was examined for the presence of blood and semen.
Okay. And what were the results? Were you able to confirm blood or semen on the shorts?
No, both of those tests were negative for the presence of blood and semen.
Okay. And then on, what's the next item that you received?
Q81, which was identified as clothing.
I'm sorry, we're going a little too fast.
Sorry.
It's my fault. Okay, and when you refer to clothing, you're referring to the item which would include the shirt, which was like the elastic portion of the shirt and the letter writings of a child's shirt?
Yes, I can read my description if that would assist.
That would be better. Go ahead.
I have it identified as containing letters, stitching, and stretch material with the letters being spelled or containing BIGTROUBLE. And there was also some stick and other debris contained with that item.
Okay. Were you able to confirm blood on that item?
No, I could not confirm blood on that item. The chemical test for the possible presence of blood was positive. However, there was insufficient quantity to continue on and confirm the presence of blood.
Okay. So you can't say in any way that there was blood on there?
Only that the possible presence of blood, that it was positive for the possible presence of blood.
Okay. And was that tested any further?
Specimen Q81 was continued on for DNA typing.
Okay. And out of that, what you thought was possible, were you able to come up with a profile?
No, sir. There was no DNA obtained from that item.
Okay. And what's the next item?
The next item is Q82, which is identified as a blanket.
I'm sorry?
It was identified as a blanket.
Okay. And on the blanket, were you able to confirm blood on that blanket?
Could not confirm the presence of blood. However, the chemical test for the possible presence of blood was positive.
Okay. And did you then take it a step further to see if there was DNA there?
Yes, that item was swabbed for DNA testing, and no, there was no DNA profile generated from that specimen.
Okay.
There was an additional chemical test also performed on that blanket.
Okay. And what other test was done on that blanket?
That item was also looked at for the presence of semen.
Okay. And did you find any?
No, that item was negative for the presence of seminal fluid.
Okay. And the next item?
The next item is Q84, which was identified as a laundry bag.
Okay. And that laundry bag, what test did you run on that?
The chemical test for the presence of blood was performed on that item, and it was positive for the possible presence of blood. However, there was insufficient quantity to continue on for a confirmatory test.
Okay. And did you then take it a step further and try to get DNA?
Yes, sir. DNA typing was attempted on that item. However, there was no DNA typing results obtained.
Okay. And then the next item.
The next item is Q103, identified as a blanket.
Okay. And what test did you run on that?
That item was tested for the presence of blood and semen.
Okay. And what were your results there?
The chemical test for the possible presence of blood was positive on the blanket, and the tests for the presence of semen were negative.
Okay. Okay. And can you give a better description of, actually, if I can have a moment to confer. Your Honor, my apologies. The blanket that was just described is not an item that's in evidence. It's completely unrelated, and I wanted to move to strike that on my own and the references to that.
And this would be as to which Q number?
Q103.
So I agree the jury should disregard any discussions about Q103. It has nothing to do with this.
And it's completely my error. Mr. Ashton and I had spoken previously in the process of going
So
through.
that's the blanket that she's just testified to?
Correct.
Ladies and gentlemen of the jury, you're hereby instructed to disregard testimony that the witness has given concerning the blanket that she's just testified to and not utilize that in the decision-making process in this case. You may continue. Thank you, Mr. Bias.
Thank you, sir. Ms. Sebert, there are other items on your report that are not in evidence, so I have to ask you specifically for which ones, okay?
Yes, sir.
And testify only to those. Can you also tell us about Q244?
We identify that with the number so that we make sure we...
That is...
Exhibit HR.
States Exhibit HR, can you tell us, give us a description of Q244?
Yes, Q244 was identified as a doll that was received at the laboratory.
And where does the doll, where were you informed the doll came from?
It's identified that the doll was collected from a vehicle, and I can check my notes to determine what vehicle specifically.
Sure, go ahead. Can we both stipulate it's the Pontiac Sunfire? Your Honor, we have a stipulation that the doll came from the interior portion of the car on the car seat.
Which car?
The Pontiac Sunfire.
Okay.
The car seat in the back seat passenger of the car.
Yes. Okay. Can you tell us what you did with that piece of evidence?
That item was generally swabbed for the presence of blood, and that test was negative. So there was no blood identified on that item.
Okay. All right. I want to take you now to your next report, which is December 16th of 08.
Is that a long report?
No, I believe I'm just got a couple minutes, and then we can take a break. Take a break.
Go ahead.
I'm aware we're close.
Sorry, can you state the date one more time on that
Yes,
report?
December 16th of 2008.
I have that report in front of me.
Okay. On page 2 of your report, were you given the profiles of Cindy, George, and Lee Anthony.
If I may refer to one
Yes,
other.
go ahead.
The question that you had asked was if I had been given the profiles from Cindy, George, and Lee Anthony.
I'm sorry, buccal swabs from them.
Correct. The buccal samples had been submitted to the laboratory under communication dated October 20th of 2008.
And and I'm referring to State's Evidence 113. Were you asked to conduct a paternity test for Lee Anthony as to Kaylee, being the potential father of Kaylee Anthony?
You may. (11:59). We're going to recess for lunch. I'm going to ask you not to discuss this case among yourselves nor with anyone else. Enjoy your lunch. You may be seated. Okay, Mr. Ashton.
The objection, Your Honor, is that counsel has no good faith basis for asking this question. He is aware, fully aware from depositions that the FBI laboratory does not perform paternity testing, that they were never asked to perform a paternity test on this case. And in fact, I'll let counsel respond and deny either one of those things I just said.
What is your good faith basis for asking the question that you were asking? Just a second.
Two things. Yes, sir.
Just a second.
Sure.
Pardon? I was going to find it, but if you can find it quicker than I can.
Were you asked to conduct a paternity test for Lee Anthony as to Kaylee Anthony, the potential father of Kaylee Anthony?
I have two very good faith reasons for asking that question. Number one, it was tested to see if Lee Anthony was the potential offspring, if Kaylee Anthony was the potential offspring of Lee Anthony. And number two, I asked this witness last night. The FBI does not normally do that, and that's what she will testify to, that they don't normally do them, but they can do them, and they did. And as far as the statistical analysis portion, they would have to refer it out to a second laboratory. So that's exactly what the objections raised by Mr. Ashton are not true. The FBI in this case did do a paternity test, but he was excluded as the potential father. And end of story. I don't understand where, if it's in black and white in an actual report, how that's not a good faith basis. And I also mentioned this when we were at the break, the items of evidence. I would assume that Mr. Ashton, knowing that it says that in this report, and we identified the actual item, that it was an area I was going to inquire about.
May I ask the witness a question, Your Honor?
You may.
Were you ever asked to do a paternity test to determine if Lee Anthony was the father of Kaylee Anthony by the state or by Orange County or by law enforcement?
If
If I may refer to my communication log for the conversation that I had with the special agent in charge before I answer that, to be clear.
Go right ahead.
You may.
Thank you. I have the conversation here noted, if I may read that to answer that question. On September 12th of 2008, I spoke with Special Agent Nick Savage. The inquiry about paternity testing / reports, I let him know we could run sample, generate results, and send our report to a laboratory for the statistical component. And this is referring to the lab. It has been a lab that has assisted us in the past, and he agreed. They do not have the sample yet.
Does that in any way mention Lee Anthony?
No, sir. Not in that particular conversation, no, sir.
Your Honor, that is my objection. While counsel is correct that by looking at the DNA profiles that were run, Mr. Lee Anthony and George Anthony can both be excluded as potential fathers for Kaylee. But to ask that question, suggesting that law enforcement specifically inquired, is not a good faith question. If he wants to bring out that, in fact, coincidentally, these test results exclude them as the father, that's fine. But to suggest by that question that that request was made by law enforcement, there is no good faith basis for that. And also, of course, it's hearsay. What a police officer may or may not have suspected or had a question about is not relevant in this case. And counsel has no good faith basis for believing that it is.
May I inquire as to the witness, if it's
You
necessary? Who did you understand they wanted you to compare the paternity test for?
Before I answer that question, there is one more entry that I wanted to read prior.
Go ahead,
Okay.
ma'am.
Go ahead.
So on October 8th of 2008, I also had an additional conversation with Special Agent Savage. And within that conversation, he would like us, it is stated, he would like us to submit the brothers' results with Kaylee and Casey to the UNT lab. A possibility of parentage is present in the results.
So it was your understanding that you were to determine if Lee Anthony was the father of Kaylee?
The question had been posed if we could run the samples and generate a result and do a comparison. Specific to paternity testing, our laboratory does not perform. However, we could have made the determination as a possible biological offspring or excluded as a possible biological offspring, and had identified the laboratory that would perform the statistic component if that had been a possibility.
So you run the test if he's a potential, if he's potentially the father, it would be sent off to another lab for the statistical component.
For this particular discussion, that was what had been laid out for this particular, these samples.
And in your report, do you report out that that based on the SDR typing results, the DNA obtained from specimen Q18-1, Kaylee Anthony, could not have originated from a biological offspring of the individual represented by specimen K9, Lee Anthony?
Yes, that is stated in that report.
The objection then is, what is the relevance of what a particular FBI agent thought or a question that he had? What is the relevance of that other than to suggest to the jury that there's some information out there that this jury has not heard? How is the good faith basis relevance of that?
I never asked that question, Judge. I'm going through her results and through the work she's done in this case. That is part of the work she's done in this case.
That is not the question counsel asked, and he darn well knows it. If he wants to ask this witness whether Mr. Lee Anthony is excluded as the father of Kaylee, that's fine. That's in the report. More power to him. But that wasn't the question he asked. That wasn't the implication he was trying to leave with this jury.
Anything else, folks?
Not really.
Okay. Let me say this. I don't know what was in your mind. I don't know what was in Mr. Ashton's mind. But you are not to ask questions that may lead to inference that unless you want to call a law enforcement officer to ask that he specifically asks to have something tested, you can get the results, as Mr. Ashton has indicated. That's a proper question. I'm not going to even venture a guess or speculate on the motivations or whether or not your question even suggested that. I would do what I told both sides to do some time ago. There's a case called the Amante Banana Company, which is found at 466 7th 2nd, page 1167. Read it. It talks about good faith basis for asking questions. There's another case, Broxson versus State, which is found at 505 7th 2nd 1361, out of the First District Court of Appeals. Please read those two cases for a good faith basis for asking questions, and that's all I'm going to say. Okay. If there are other exhibits you need to line up for afternoon witnesses, please let the clerks know so those exhibits may be pulled. We'll be in recess until 1:30. Yes?
I do have a motion to strike. I'd ask to strike counsel's last question and have the jury, when they return, be instructed to disregard the question.
Folks, I will look at the question, but all I'm going to say is this. I don't have a hearing problem. And the amplification of questions, objections, I don't need them. Okay? I can hear in normal voices. Okay. I will ask the court reporter to mark the last question. I will review it when I come back, and I will consider that. Okay, we'll be in recess to 1:30. You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to proceed.
Yes, sir.
Okay. Now, do we know what your next question is going to be so we don't?
Well, that's the, I want to know, I don't want any issues, so I want to know how the court.
The last question you asked you asked the following question before we went to sidebar.
Mm-hmm.
Were you asked to conduct a paternity test for Lee Anthony as the Kelly Anthony, potential father of Kelly Anthony?
Yes, sir.
Okay.
That's what I believe she was asked to do. I don't know if.
And Mr. Ashton, your objection, sir.
The objection is it is not relevant whether anybody asked that question. The relevant is whether a test was done and what the results were. The question. Sorry, go ahead, sir.
One at a time.
My apologies, sir. That was my fault.
No, you go ahead.
I can rephrase.
Okay.
I can rephrase the question. Did you conduct a paternity test for Lee Anthony? I won't ask if she was asked.
Okay. All right. Since we're now all on the same page, let's return to jury. Okay, state recognized presence of jury. And the defense?
Yes, sir, we do.
Okay, members of the jury, did you heed all of my previous admonitions during the noon recess for lunch? Okay. Apologize for starting late, but we had elevator problems. All right, Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court. Mr. Ashton. Good afternoon, ladies and gentlemen. Good afternoon, Ms. Sebert. Sorry.
Good afternoon.
Where we left off, I wanted to ask you if you conducted what would be considered a paternity test to determine if Lee Anthony was the biological father of Kaylee Anthony.
Can I have the date of that report one more time?
Sure.
That we're discussing.
That's December 16th, 2008.
And you said December 16th, 2008?
That's what I believe the date. Yes, that's the date I have. And I would be referring you to page 2 and 3, specifically 3 of your report.
I apologize. I had that report out earlier prior to the recess, and I'm just trying to find that one again. I apologize.
No problem.
I have the December 16th, 2008 report in front of me, and you're directing me to page 2.
I believe you start on page 2, but the results of your examination are on page 3.
The report I have dated December 16th, 2008 does not address the question that's
I know you have two reports that.
Okay.
You might look at the other one.
Would it be okay if I looked at the report that you had in front of you?
May I approach the witness,
Oh,
Your Honor?
thank you, Your Honor.
Thank you.
Yes. Go ahead.
And can you read to the ladies and gentlemen of the jury, page 3, with your results?
Yes, on page 3, it states, based on the STR typing results, the dean, apologize. Based on the STR typing results, the DNA obtained from specimen Q18-1, Kaylee Anthony, could not have originated from a biological offspring of the individual represented by specimen K9, Lee Anthony.
May I approach the witness?
You may.
Now, these types of tests are not done very often at the FBI laboratory, are they, ma'am?
Objection, relevance.
Relevancy?
Just explaining the evidence a bit more, Judge.
Sustained.
Okay, let's move on to that same report, which you don't have. May I approach the witness again, Your Honor?
You may.
I have found it now. Thank you.
Can you explain to the ladies and gentlemen of the jury what Q47 is? And just for the record, the defense and the state have entered into a stipulation to discuss these items without objection.
Does Q
The car, yeah, that's correct.
47 have a reference exhibit number?
It would be identified as, and we would stipulate that it is the car seat, which is shown in the photographs from the Pontiac Sunfire.
Okay, thank you.
Thank you. Can you tell the jury about the car seat? What you did?
Yes, I can. Q47 was identified as a car seat from the 1998 Pontiac Sunfire, and that item of evidence was examined for the presence of blood, and the chemical testing performed was negative.
Did you do anything further beyond testing for blood?
On Q47, the car seat, no, I did not.
Okay. And Q48, can you tell the ladies and gentlemen of the jury what that is?
Q48 was identified as the steering wheel cover.
And what did you do with that item of evidence?
The steering wheel cover from the Pontiac Sunfire steering wheel. So the jury knows what we're talking about.
On that particular item, it was visually examined for the presence of any biological stains, and through the visual examination, there were no biological stains observed, so therefore no chemical testing was conducted.
Okay. And Q55 and 56, can you identify what items they are and where they came from?
Yes, Q55 was identified as debris from the spare tire wheel well, and Q56 was identified as a swab from the spare tire wheel well.
And other than the other report that we covered that is dated the 16th, which deals with identifying Kaylee, have we gone over all of your reports?
Yes, sir.
Okay. I have no further questions for this witness.
Cross-examination.
Good afternoon.
Hello.
I want to take some time and go through what these results mean or don't mean.
Okay.
Let's begin with the Exhibit 15 in evidence, which is identified as the swabbings from the spare tire cover. All right? You indicated that you did a phenolphthalein test on that, which is a presumptive test for blood.
That's correct.
What does the phenolphthalein test actually react to in blood?
It is actually reacting with the heme portion of the blood.
And when you say the heme portion, can you let us know what you mean by that?
Sure. It is part of the substance that's carried along on the red blood cell that we're actually looking for. And it's basically a test where it's an oxidation reduction test. I know it sounds kind of technical, but it's a test where the first chemical that's applied is going to react with the heme, and then once you add the second component, it actually oxidizes it, causing that color change if the heme portion is there and is present.
And is the heme portion only found in intact red blood cells?
Well, it could certainly, if you had some broken down red blood cells, if it's still attached there, you could have some residual that could be present. But as you start to break down the red blood cells, you're starting to then also break down the heme portion that's present.
So when a body decomposes, blood decomposes, the hemoglobin also decomposes.
That would be a correct assumption, yes.
Is this test in any way indicative of whether a certain substance is fluid of decomposition of a human body? Is it sensitive to that, other than if there's whole blood cells?
Not sure if I understand.
Let me rephrase it. That was a little sloppy. Would this test react to other substances in the body like fat?
If there was any type of presence of that heme portion from the blood that could be connected when you talk about where fat is deposited, it is possible.
Okay, but only if there's relatively intact red blood cells.
Correct.
But if the blood cells have decomposed, then it wouldn't react. Or it's less likely to react.
Less likely.
Okay. I guess what I'm getting at is the particular stain that you test has been identified as being decomposition fluid from a
judge assumes facts not in evidence.
Overruled.
Has been identified as a stain from fluid from decomposition of a human body. Does your
objection misstates the facts, Judge?
Overruled.
Does your test refute that?
Well, I can't speak to whether or not there was a blood or decomposition fluid present there because my test is negative, so I can't.
All we can say is your test did not detect whole blood cells.
It didn't react with any type of substance that was present there. Whole blood cells that maybe were, as we talked about, partially broken down. So I have nothing that would indicate that there was blood contained on those items.
But you indicated it could be decomposed fluid, including decomposed blood, that might not react.
Well, the test.
It's the testimony of the witness.
Just
Witness never testified in such a thing.
Objection sustained. Rephrase your question.
I guess what I'm trying to figure out is, does your test indicate that the stain was not the fluid from a decomposing human body, in your opinion?
Based upon my testing results, it's negative, so I can't testify to anything other than the evidence that was there that I tested was negative for the presence of blood, which I can't state anything other than I didn't detect any biological material, blood, or other fluid based upon my results.
could the stain still be decomposition fluid?
Objection, ask and answer.
Overruled.
As far as if there were other biological fluids that could have been present in there, it's possible.
Okay.
But based on my test, I can't say anything other than it was negative.
All you can say is it wasn't blood.
Correct.
Okay, I've got that straightened out. Now, what happens to DNA when cells decompose?
Well, as cells decompose, the DNA is going to start to also be degraded. Because if you think about where the DNA is housed inside the nucleus of a cell, if the cells start to break down, eventually it's going to get to that center portion, the nucleus, which is also going to cause the DNA over time to also start to be diminished, losing the information that's present.
And in order for DNA testing to work, you have to have intact strands of DNA.
Right. With the 13 locations that I examine as a part of my analysis, if I have portions of those locations still present on the chromosome, I may be able to obtain a result.
But generally with decomposing cells, you don't generally expect to find DNA.
Objection, ask and answer.
Sustained.
I'm sorry, Your Honor, I don't believe she answered that exact question. It is cross-examination, Judge, so I would ask for some leeway to get...
One more time.
If I get the court to read back the question.
But generally with decomposing cells, you don't generally expect to find DNA?
Right. As the body breaks down, that information that's housed in the nucleus of the cell is also going to start to break down. And so the likelihood of obtaining a DNA result does start to diminish as the body starts to decompose.
Now, I want to go to this chart. I don't think I need to step down. I think you remember when it was written. I want you to clarify for the jury what this result means.
Yes, you may.
This result that counsel wrote on this chart, this 50, I guess 55 was the RFU. What does that really mean?
Okay, so the two numbers that are circled there, the 50 is what's referred to as the peak amplitude threshold, or the first level of detection for what's considered a peak in the FBI laboratory's DNA analysis unit, which is based on validation and testing to support what's a reliable result in the laboratory. So during the capillary electrophoresis process, when the DNA is injected into the capillary column and the DNA strands are traveling through that capillary column, at the end there is a laser. And those DNA strands have been tagged with a fluorescent tag, which enables then that laser to detect the signal of that DNA strand as it passes by. And that's the fluorescence that's then collected. And that's the end result, that DNA profile, based on how much fluorescent was detected at each of those locations, which is then generated into the peaks that we talked about at each of those locations. So at 50 RFUs, that's when the computer interprets if there's enough signal there to determine that a peak can be called. That's the first initial, it'll flag it as a true peak. And that is based, again, on the parameters that we've set at our laboratory to determine it is a peak. The next level...
Let me stop you for a second, because you kind of answered. I wanted to ask you specifically about the 55 peak that Mr. Bloise was asking you so much about. In the context of this evaluation of this evidence, what does that mean, if anything?
A peak at 55?
The one you talked about the amylogenic peak at 55.
So a peak at 55, depending on which location it's detected at, and in this case was discussed, it was at amylogenin. Again, there's a peak detected, but it's only a sole peak at amylogenin. And so based upon the information that I collected from that, determined that it was inconclusive. I cannot give any information about what that peak exactly means.
The amylogenin is a specific chromosome. You're looking at the sex chromosomes, correct?
That's correct.
And this particular result you got is consistent with either being a male or a female. You just can't tell.
Well, the only part of that sex chromosome that's appearing is the X. There is no Y, and it is at a limited level. I felt it was more conservative to say it was inconclusive. There is just information about one peak there, but is it any information that I can give weight to? I couldn't state that, and therefore I said it was inconclusive.
Now, just so the jury doesn't misunderstand, does this mean that there is potentially an entire DNA profile there that could be enhanced with one of these other techniques that counsel was talking about?
Well, to perform low copy number, that would have to be the initial beginnings at the very start of the DNA analysis. So that would be an enhanced DNA process that the time I was in casework was not being conducted. And so if you were to take that same sample and perform a low copy number technique on it, I don't know what type of result would be generated. I can't speak to that.
It would be complete speculation to say that this would mean anything.
Right, I don't know.
But even if this were enhanced to a readable portion, it would only tell you whether it was a male or female.
Again, I don't know. It's possible, but I don't know.
Okay, there was a discussion about a single result on the sticky side of the tape at a 17 loci. Is that correct?
At the locus D3, it was a 17 allele. Again, well below the threshold.
Well below the 200 threshold.
Correct.
All right. Was there one of the individuals that you tested at the laboratory who had contact with the tape?
May I approach?
Yeah. let me see the attorneys. I don't need to see the court reporter, but let me see the attorneys for a second. Okay, ladies and gentlemen of the jury, I'm going to permit Mr. Baez to ask an additional question that will provide some type of clarity to the issue. You may proceed.
Thank you, sir. Ms. Sebert, we're talking now about the 17 marker, the 17 allele that is on the D3 marker on the sticky side of the duct tape.
Okay.
Okay. When you saw this, did you attempt to eliminate other individuals other than Casey and Kaylee Anthony?
Yes.
Okay. And what did you do to attempt to do that?
The same process that I did with the top side of this tape, I would have done with the underside of the tape, where I would have compared that type at that one location to all of the reference samples from the laboratory personnel, in addition to the known samples that had been submitted as part of the case that I mentioned previously.
Okay. And this is a little different because you only had one marker, correct?
That's correct.
Whereas with the other one you had 6? Just clarifying it all up, Judge.
Let's get to the point. Objection overruled at this point.
You can answer the question.
Correct. On the top side of the tape, there were results at 6 of the loci, or locations, or markers. On the underside of the tape, as far as the locations for the STRs, there was a peak, as Mr. Baez has pointed out, a 17 that was present at the D3 locus.
And how many people did you go through? How many people did you look at to see if they had a 17?
I went through the 5 known samples that were submitted as a part of the case, or the profile that was generated for Kaylee Anthony, the known sample for Casey Anthony, the known sample for Cindy Anthony, George Anthony, and Lee Anthony. And then I compared it to the known reference samples that were from the laboratory staff. And there were a total of 5 individuals from which I collected a sample from, and DNA profile was generated for them.
And did you find someone that could not be excluded?
Again, based upon the report language that I utilized, I did not draw any conclusions to the information at that location. Based on my report, it says that that information was inconclusive, and was not utilized for comparison purposes.
So if I understand you correctly, it doesn't meet your threshold to either include or exclude anyone.
It was very limited, so I didn't feel that it was suitable for that comparison, to report out a comparison in my report.
Was there another individual that had a 17 at the D3 marker that you looked at?
There was an individual, as a part of their DNA makeup at that particular locus, the D3, they did have one of their alleles was a 17.
Okay, what did that person have at the D3? What were their?
The DNA makeup at that particular location for that individual was a 16-17.
However, you didn't see any 16 at the D3 local from the duct tape, did you?
This goes beyond what the court allowed my cross to be interrupted for.
I don't believe so. This is clearing up the issue, Judge. This is what I would have done under direct.
You may continue.
There was, what was on the duct tape, there was no 16, correct?
The peak there was just the 17 that was at the level of detection for a peak.
So, just so the ladies and gentlemen of the jury can understand, this could be two things. A person can have two alleles, or a person can have one peak, like you had described earlier, correct?
Correct. You're either a heterozygote or a homozygote. Heterozygote having two peaks, like you referenced, or a homozygote just having the one peak.
Okay. And the person that is a lab personnel is a heterozygote, meaning they have two peaks.
That is correct.
But all you found was one peak.
One peak that was reported, correct.
Now, because it's so low, you can't make a determination at all as to either way, correct?
That's correct. As I stated, it was inconclusive for reporting purposes.
But what you can definitely say is that there is no 16 at the D3 marker for that peak.
Using the thresholds that we've discussed from the FBI laboratory, that is correct.
I have no further questions.
Okay, Mr. Ashton, you may continue.
The reality of it is that this peak really means nothing. It's inconclusive. It really shouldn't be taken to mean anything. Isn't that really the reality of this?
And that is the result that I provided in my report, that it was the results for that were inconclusive.
And the reason for that is because at those low thresholds, you can drop out alleles. In other words, you can have someone with a 16, 17, but the 16 is so low it doesn't appear.
That's correct, referring to stochastic effect, where you have alleles that may be there at one amplification, and you may not get the same result at the next amplification because it is such a low level of DNA.
And that's why the scientifically responsible attitude toward this is simply, it's inconclusive, it doesn't mean anything.
That's correct.
But if it meant anything, it's not the DNA of George Anthony, correct?
At that particular location, Mr. Anthony did not have a 17.
All right. Okay. Now,
Mr. Ashton, may I ask one question?
Sure.
Would that be okay, Judge?
Yeah.
I just want to be clear, the DNA types that we did talk about earlier about the same tape for Kaylee Anthony and Casey Anthony, I just wanted to be clear on the types. I think I may have misspoke with the types that were at D3, so I just wanted to be sure the jury was clear on the types that were present, if that would be appropriate.
Right ahead.
Okay. Kaylee Anthony at D3 is a 14-15, and Casey Anthony is a 15-19. And I think I had referred to them both being a 14-15, and I apologize for that.
Now, let's see. We've talked about the... Mr. Bloise spent a great deal of time asking you about blood. You test for blood on items of evidence for the possibility that blood was shed during some event, correct?
Correct. That's one of the forensic examinations that's performed in the laboratory.
That's not what was testified to. She testified that she tests for blood.
Oh,
It's one of the examinations to examine items of evidence for biological fluids, and blood being one of them. I cannot speak to possibly how the nature of the substance would get on the item. I'm just looking for it to detect if there is any biological fluid present.
For instance, if someone is shot, there may be blood spattered or bleeding from a wound, something like that.
That's correct. Sure.
Or if someone is stabbed, there can be blood, again, gushing from a wound that might be on a piece of evidence.
Sure. That's correct.
If someone is killed in a manner that does not shed blood, the absence of blood doesn't indicate the absence of the crime. Would you agree?
Objection, Judge, calls for speculation and outside this witness's area of expertise.
overruled.
I'm sorry to
Sure.
make you, could you repeat it one more time?
That's okay. I'm just talking about the significance of the lack of blood on a particular crime scene. If a method is used to kill someone that doesn't involve bloodshed, then the absence of blood doesn't really say it didn't happen, correct? I mean,
Correct. I couldn't, correct. I couldn't speak to whether or not it happened or not.
Okay.
Right.
Now, let's see, we've talked about the items from the trunk. Oh, the tape. Were you involved in any way in the discussions about the order of examination of the tape? In other words, what should come first, second, third, those kind of things?
No, sir.
Okay. It's true, is it not, that you, based upon the history you were given of this tape, would not have expected to find any DNA from the victim on the tape? That's correct, isn't it?
If I may answer without
Sure.
yes or no. The expectation would have been on the sticky side of the tape if it had been, in fact, across the face of the victim. That would be the possible area where I would expect to find DNA, but again, with the information about where the exposure and length of time, I didn't expect that there would possibly, the expectation was neither here nor there. It was a test that was performed, but if there was going to be DNA, the expectation would be that it would be on the underside where cells would be collected on.
But for DNA to survive on an object in a swampy area for 6 months would be unlikely in your experience. Isn't that correct?
Sustained.
Your Honor, I believe we have expert testimony. May I argue
Yeah.
the bench? Because I do.
Yeah. You may proceed.
Let me just ask, how was the area where the remains and the tape were found described to you?
It was described in an electronic communication as being an area that would have water coming into it in a swampy type area.
All right. Now, what would happen to any DNA on the tape under those conditions in Florida, in the heat, for 6 months?
Well, if water was coming in and receding out and drying and humidity, it is probable that if there were cells contained on there, that the cells could start to degrade over time, and the DNA that would be contained in there would also start to be diminished and to degrade.
Okay, thank you. And would that same answer apply also to things such as the shorts or the other closing items that you were asked to examine from the same scene?
Yes, sir.
Now, in this case, Mr. Baez asked you about something he called a paternity test. The FBI doesn't actually do paternity testing, does it?
No, sir.
In testing the known samples you were given from Cindy, George, Lee, Casey, is it possible, and eventually from Kaylee, correct?
Yes, sir.
And just so we're clear, the sample from Kaylee was marrow from one of her bones. That's what you ultimately tested.
Beyond the scope of direct.
Overruled.
Is that correct?
There were 2 samples that were processed for the identity of Kaylee Anthony. One was initially a toothbrush, and then the tibia was submitted, which was ultimately the powder from that tibia was utilized to process and generate a DNA profile.
All right. And Mr. Baez asked you about a quote-unquote paternity test. What you actually did was look at an existing profile of Lee Anthony, the profile you got of Kaylee, and make a determination as to whether he could be the father, correct?
All right. I generated the DNA type from Mr. Lee Anthony and using Casey Anthony's DNA type, taking the 2 of their DNA profiles and comparing that to Kaylee Anthony to determine if there were alleles present that would suggest those 2 individuals.
And there weren't.
That's correct.
So to summarize all of the testing that we've discussed here, the stain that was in the trunk of the car, all you know is it's not blood.
That's correct.
You can't tell anything other than that.
That's correct. I did not generate a DNA profile either. That's correct.
And the only DNA on anything from the scene is explainable by DNA from lab personnel. Would that be a fair statement?
Misstates the facts and evidence.
Overruled.
From the outdoor crime scene, in addition to identifying Kaylee, the only DNA profile that was generated from the outdoor scene was that of a laboratory staff member.
No further questions?
Redirect.
You testified, Ms. Sebert, about decomposition in the trunk and talked about as cells break down, there's no longer an ability to get DNA, correct?
It diminishes over the time period. That's correct.
And that's what I want to ask you about. You can't testify as to at what point during the decompositional phase that you would not be able to get DNA, can you? Except the later stages.
There's many. It's hard yes or no answer, Your Honor.
answer it?
Just explain it away.
Okay.
Go ahead.
So, well, it depends on what exactly, when you talk about obtaining a DNA profile, you're trying to do. Are you attempting to generate a known DNA profile for the identity of that individual, utilizing a bone, utilizing a tooth? Those are the types of body parts that will remain. The skin, the tissue, the blood, and that over time will start to decompose and start to disappear. But the more hardy, for lack of a better word, the hardy areas in the body will remain. But as a body decomposes, all of those tissues, cells, and fluids that are contained within us will start to degrade, and the ability to generate DNA from the collection of those types of cells and bodily fluids diminishes.
And that happens at the latter part of decomposition, does it not?
Objection, leading.
Sustained, rephrase the question.
Yes, sir. Does that happen at the latter part of decomposition?
Objection, leading.
Overruled.
When you ask the question at a latter part of decomposition, are we talking, what is the environment for that decomposition that's happening? Is it in a hot environment? Is it a cold environment? Because all of those factors are going to play a part in how the body breaks down.
Right.
And so in order for me to give a scientifically based answer as to where is the period in time that I can no longer generate a result, I can't give you that answer.
You can't say.
I cannot say.
Okay. However, what you can say is that you did not get DNA or blood from the trunk of that car, correct?
That's correct.
And is it your understanding that in the early stages of decomposition, there is blood?
If you think about what's running through our bodies, there's the circulatory system comprised of blood. And so as a body starts to decompose, those fluids are going to start to leak out from the body. So the possibility would exist.
And there's also a possibility that blood would leak onto a carpet of a trunk liner.
Objection, beyond the scope of expertise.
I think the witness...
Just a second.
Yes, sir.
Ma'am, can you answer that question within the scope of your expertise?
Yes, sir.
Then you be permitted to answer.
Go ahead.
Well, within the confinement of a trunk, if a body is placed there and it's slowly going to decompose, all of those fluids are going to start to dissipate into that carpet or the trunk liner if that is contained within the trunk and the body is just placed there and not contained with any type of protective material. It would just be placed there as such.
And if it is contained in a plastic bag and there is a hole in the plastic bag in the front where you tie it up, could it leak out of that area? Is it possible?
Sure, it's possible.
Okay. Now, I think I just have one. The summary that you gave on as to the items recovered at the scene, you could only testify to the contamination aspect of the potential contamination of the lab person on the non-sticky side, correct? Of the duct tape?
Objection, leading.
Sustain, rephrase your question.
When you gave that answer, you were considering what is reportable through your protocols, right?
Objection, leading.
Sustain.
Were you taking, let me ask you this way. As you were giving the answer to Mr. Ashton in reference to what you were able to get out of the scene, did you take into consideration your protocols? What your reporting protocols are?
When I gave the answer to Mr. Ashton, I was giving that based upon what I've issued in my FBI laboratory report.
And that's based on the protocols that you're allowed to report out?
It's based on the standard operating procedure of the laboratory, correct?
And the 17 allele that you can't make any conclusions on, you did not take that into consideration when you issued your report on that.
Well, as discussed, that information for that portion of the tape could not provide a conclusion to. It was inconclusive. And so in my answer to Mr. Ashton, I was considering what I issued in my laboratory report, and that was a part of it.
And when you discussed about the elements, the outdoor elements, did you consider let me rephrase that. When we were discussing the outside elements and the potential of being able to find DNA, you did say that the expectation, if duct tape were placed around someone's mouth and there was if duct tape was placed around someone's mouth, you would more so expect to find that DNA on that portion than the non-sticky side. Right?
Sustain.
Would you expect to find more DNA on the sticky side or the non-sticky side?
My expectation would be that if there was DNA recovered, it would be more probable or more likely to be on the sticky side.
Thank you, ma'am.
Just one quick question. When fluids leave the body, they continue to decompose, don't they?
Yes, sir.
So even blood that is spilled on a surface, if it's hot or wet, it'll continue to decompose.
Yes, sir.
Thank you.
May the witness be excused.
Yes.
Thank you, ma'am. You may be excused. Okay, ladies and gentlemen of the jury, the time is now approximately 15 minutes to hour 3. We're going to take a recess at this time until you need a special one. Okay. Then we'll take a recess to 5 past the hour of 3. Please do not discuss this case among yourselves nor with anyone else. Thank you. You may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to proceed.
Yes, sir.
All right, yes, you may. Okay, who will be your next witness, Mr. Baez? Let's return to jury. Okay, state recognized presence of jury. Defense,
Yes, sir, we do.
you may call your next witness.
The defense would call Robin Maynard.
Stand, raise your right hand and sign out.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth.
I do. Please.
Robin Maynard, Maynard.
You may proceed.
Thank you, Your Honor. Ms. Maynard, how are you employed?
I'm the founder and executive director of Libby's Legacy Breast Cancer Foundation.
And back in 2008, How were you so employed?
I was a crime scene investigator with the Orange County Sheriff's Office.
Okay. And you were the person that actually collected an item of evidence 313 in this state's evidence 313. May I show you a photograph of that?
Of course.
Your Honor, may I approach the witness?
Yes.
Do you recognize that item, ma'am?
I do.
Okay. Can you tell the ladies and gentlemen of the jury what that item is?
It is a cardboard mat with a pink heart-shaped raised material.
May I publish a copy of that to the jury as well?
You may. Exhibit number what?
313?
All right.
The photograph is.
The photograph.
Oh, the photo.
No objection. The actual item is, but that photograph needs to get a separate number.
I think the photograph does have a separate number. If I can. Defense Exhibit W.
Okay.
No objection to its introduction.
You want to introduce it?
Yes, sir.
Okay. It'll be introduced as defense number.
Ma'am, when you collect an item of evidence like that, what do you do to record where you found it and a description of it?
I was in charge of the sifting operations, and that's quite different than how we would normally collect something because they're coming in, items were coming to the sifting stations in buckets. So, for example, a map couldn't be made in the primary search area of items I found because we only had a baseline measurement. So, as buckets would come to the sifting stations, they would have the searcher's initials, the lane number, and the coordinates for where that item was. We would sift, and when an item of evidentiary value or items to be collected were collected, I would photograph the item, note on the bucket where it came from, which would indicate to me lane, coordinate, and tell me how many feet that was.
Okay. And what lane was this found in?
This item appears to be from lane 6.
Okay. And how many feet from the baseline was it?
I have here in my marker that it was 45 feet west of the baseline.
Your Honor, I'd like to publish Defense Exhibit AT and introduce this with conditions from the state, and I have stipulated that it is not to scale. Is that correct? But it is not to scale, but it's still open.
What says the state?
No objection with that stipulation.
Okay. You'll be received in evidence as.
Exhibit number 17.
You wish to publish?
Yes, I do, Judge. I apologize. My apologies. Was everyone? Did the jury see the last photograph?
No.
That's my fault, Your Honor. I apologize. Can I publish?
Put the
that
last
first?
one back up. Which is what?
This is 16. Defense 16.
Okay.
W?
I think this thing is breathing. Oh, perfect. Okay. Now, can you indicate to the ladies and gentlemen of the jury where you indicate that it's lane 6, 45 feet from the baseline? Okay. Can everyone see that? Okay. Okay. Now, at this time, Your Honor, I'd like to publish Defense Exhibit AT, which will be admitted into evidence as Defense 17.
You may.
Can you show the ladies and gentlemen of the jury where lane 6 is? And can you show the ladies and gentlemen of the jury, let me clear this out. Where 45 feet from the baseline would be, and lane 6. And taking into consideration this is not to scale, where are the areas where the bones were found?
The areas where bones were found in the sifting, there are other items that are not here. The bones that were found through sifting only, this is not in the primary search area, are indicated in a general way where it says bone location. It can't be exact because it came from a bucket that was sifted in a general area that was specific to about 5 to 10 feet.
And that's what's indicated in the white dots?
Correct.
Okay. And is it fair to say that this is just a general, you're not pointing one bone was found at each dot, correct?
No, those are each bones. I believe there were 13 bones that were found in sifting. Okay. And so based on the lane coordinates, I did a general map when bones were found, and I would collect them where they were located based on the coordinates on the bucket.
Do you know if any bones were found in this area here?
I believe there was a bone found in lane 6, and I'm not certain how many feet west of the baseline that it was.
Okay. I have no further questions for this witness, Judge.
Cross-examinations.
No questions on cross.
May the witness be excused.
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you.
The defense may call their next witness.
The defense will call Ron Murdoch.
Sir. Please stand, raise your right hand, and say out loud.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Yes, sir.
It's Ronald Murdoch, M-U-R-D-O-C-K.
Thank you, Your Honor. Mr. Murdoch, how are you so employed?
I work for the Orange County Sheriff's Office as a supervisor in the forensics unit.
Okay. I'm going to ask you had previously demonstrated that you had drawn up a mapping system through a map through a software system. Can you open that up and because I'm going to ask you to demonstrate something if you can.
Yes. Would you like me to hook it up as well?
Yes, please. Okay.
Yes. Yes, sir.
Can you draw I realize you don't have the exact spot to where the heart-shaped sticker on the cardboard that was attached was found, but from lane 6, 45 feet from the baseline, can you tell us how far that is from area A where the skull was found?
So 45 feet from the baseline?
Yes. Lane 6.
Okay.
Okay, can we publish, Your Honor, to the jury?
No. I mean, I plug it all in the back?
Yeah.
Yes, sir.
Well, it's not up on the screen.
There we go.
Okay. You
Okay.
wanted it published, right?
Yes, sir.
Can you see it, members of the jury? Okay.
And how far is the distance from the skull area to where 45 feet from the baseline lane 6 is?
It's approximately 30 feet. Again, that's basing that upon the middle of lane 6 and the approximation of the area in which that was taken, that heart-shaped sticker and that piece of cardboard.
Okay. And how far would you say Q63 and 64, the two pieces of duct tape, were away from the skull area? You don't have a measurement like that, or would you say?
Are those the two items that were on the diagram as duct tapes 2 and 3?
Correct.
Okay. I can bring those up if...
I object, that's inaccurate.
Are you? So the best that you can give as far as an estimate as to where the sticker found was compared to where the skull was found is 30 feet away?
Yes.
Okay. Can I have you, for the record, mark and give an indication of an X on State's Evidence 279? May I approach?
No. Right.
If you could just place
And what is it that you want me to mark, this location?
Yes.
Okay.
Okay. I have no further questions for the witness, Judge.
May the witness be excused.
Yes, sir.
Thank you, sir. Please retrieve the exhibit. Next witness.
We would call crime scene investigator Welch.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. My name is Jennifer Welch, W-E-L-C-H.
Your Honor, prior to this witness testifying, both the defense and the state have entered into a stipulation as to defense exhibit AS, AR, AQ, AP, AO, AN, AM, and AL to admit them into evidence.
What says the state?
That's correct. I have no objection to their admission.
Then those exhibits will be received in evidence as defense exhibits.
AS will become defense exhibit number 18, AR will become defense exhibit number 19, AQ will become defense exhibit number 20, AP will become defense exhibit number 21, AO will become defense exhibit number 22, AN will become defense exhibit number 23, AM will become defense exhibit number 24, and AL will become defense exhibit number 25.
Good afternoon, Ms. Welch.
Good afternoon.
You were in charge of documenting the scene off Suburban Drive, were you not?
Yes, I was.
And were there a large number of items that appeared to be disposable waste in that area?
Yes, there were.
Okay. Summed it up, without getting too technical, would you consider it trash?
Yes, some of them were.
Okay. And were a lot of these items collected?
Yes.
Okay. I believe you testified previously that there were over 300 items collected?
Yes.
Okay. And did there ever reach a point where you just stopped collecting trash?
I recall there were some large items, but I don't recall at what point that was.
Okay. Now, are you familiar with the different lanes and the setup as far as the measurements from the baseline?
Yes.
Can you tell me if there were any bones found past lane 6, 45 feet from the baseline?
May I refer to my documentation?
Absolutely.
I'm having to refer to a printed diagram, and in referring to that, there does not appear to be any bones collected past that location you stated.
And I'd like to show you some photographs, with the court's permission, of different items of trash and see if you would characterize this as some of the items that were collected.
Okay.
May I publish, Your Honor?
Yes, please refer to them by the exhibit.
Yes, sir. Defense Exhibit AM.
Well, have they been remarked?
Okay.
If you head them to the clerk so she can remark them.
Yes, sir. Does that appear to be, I'm showing you defense evidence 24. Does that appear to be generally what was collected through the area, through the sifting area off Suburban Drive?
I don't recall this being found through sifting, but I recall it being found through searching and clearing of the vegetation.
Okay. Were any of these items submitted to the lab for further testing?
Not that I can recall.
Okay. Now showing you defense 25. Does this also appear to be certain items that were collected?
Yes.
Okay. And do you know if any of these items were sent to the lab for further testing?
Not that I recall.
Actually, let me stop you there. Can you identify what lane this was in based on the photograph?
Yes. As can be seen in the photograph on a card that I had written, these are miscellaneous items collected from lane 4.
Okay. And I'm now going to show you Exhibit 23. And does this look like items that were collected?
Yes, it does.
And were any of these items sent to the lab for further testing?
Not that I recall.
And what lane did these come from?
As indicated in the photograph on the card, they are miscellaneous items collected from lane 1.
And to put it in perspective, I'm going to show you Defense Exhibit 17 again. Would lane 1 be this area here, this lane?
Yes, as indicated on that diagram, yes.
Okay. And lane 4 would also be indicated there in that diagram?
Yes, it would.
I'm going to show you now Defense Exhibit 21. Were these items collected?
Yes, they were.
And were any of these items sent to the lab?
Not that I recall.
And what lane were they found off of?
As indicated in the photograph on the card, they're miscellaneous items found in lane 3.
And could you just point really quick on the prompter where lane 3 is?
Yes.
Okay. I'm now showing you Defense Exhibit 20. Were these items collected? Let me turn it upside down. And were any of these items sent to the laboratory?
Not that I can recall.
And what lane were these collected from?
As indicated in the photograph on the card, they are miscellaneous items from lane 3.
Can you indicate briefly where that is? I'm now showing you Defense Exhibit 19. Do these appear to be items that were collected?
Yes.
And can you make out what lane those were found at?
Not in this photograph.
Neither can I, so I'll move that out. And now I'm going to show you Defense Exhibit 18. Were these items collected?
Yes, they were.
And were any of these items sent to the lab for analysis?
Not that I recall.
And where does it say this was found?
I can't quite read it in the photograph.
Let's see if I can zoom in a little bit. Can you make that out now?
Yes.
Okay, where was that collected?
According to the card in the photograph, as indicated here, they're miscellaneous items from the clearing area east of the wooden fence.
Okay. And where just generally would that be located? From here, if you can just point in the general direction.
Yes, the general direction of the wooden fence would be along this side. I don't recall exactly what lanes it would have matched up with.
Okay. I have no further questions for this witness, Judge.
Cross-examination.
Just one question. Investigator Welch, would it be fair to characterize the area where Kaylee Marie Anthony's remains were discarded as a trash dump?
Yes, that's what I would classify it as.
Thank you.
May the witness be excused.
Yes.
Thank you, Investigator Welch. You may be excused.
Thank you.
The defense may call their next witness.
The defense would call Lori Goddman.
Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you?
My name is Lori Goddman. That's spelled Lorie. Last name is Gottesman.
And how are you employed, ma'am?
I'm employed at the Federal Bureau of Investigation, Laboratory Division.
Okay. And what is your occupation at the FBI laboratory?
I'm a supervisory forensic document examiner.
And how long have you been employed there?
I've been employed at the Federal Bureau of Investigation since 1992, just shy of 20 years.
And can you please share with the ladies and gentlemen of the jury your educational background?
Yes, I received a Bachelor of Arts degree in psychology from the George Washington University in Washington, D.C., and a Master of Science in Forensic Science from National University in San Diego, California.
And what is the nature of question documents? What does that mean?
Well, as a question document examiner, I examine all different types of documentary evidence. That would include handwriting, handprinting, printing processes, typewriting, plastic bags, shredded paper, torn paper, alterations, obliterations, charred documents, and liquid soap documents. For example, I compare those items with question items with known items for the purpose of trying to determine the question item's authenticity or origin.
And what kind of training do you have in that area?
Well, to become a document examiner at the FBI laboratory, I underwent an intensive training program there at the FBI laboratory. The training included classroom instruction, reading from related books and journals. I attended professional meetings. I went and toured factories. I took tests. I had oral boards. And most importantly, I worked actual cases under the guidance and supervision of actual certified document examiners.
And is question documents not just relating to documents, it relates to a whole different field, does it not? A whole different field, different types of materials, I guess is what I'm asking.
Well, it doesn't necessarily need to be on documents. Sometimes writing can be on different types of surfaces. For example, sometimes a person might write a threat on a bathroom wall, for example, so I might examine the writing on a wall, graffiti, that type of thing. So any type of writing might be on a different substrate. I mentioned torn edges or torn items. It could be some type of packaging that needs to be put back together. So it doesn't necessarily need to be a document. It could be other types of substrates that I look at. So it's not necessarily documents, but it's included in the question documents unit.
Okay. And do you belong to any professional organizations?
Yes. I'm a member of the Mid-Atlantic Association of Forensic Scientists. I'm a member of the American Society for Testing and Materials. And I'm also an assessor for ASCLD Lab, which is the American, for ASCLD Lab, which is the organization which accredits the laboratories.
Is that the American Society of Crime Laboratory
Directors, Laboratory Accreditation Board, thank you. I just drew a blank for a second. And that's international. And I think that's it for now.
Okay. Have you ever been admitted as an expert witness to testify on question documents in court?
Yes, I have.
How many times?
Well, I'm not exactly sure, but somewhere more than 20, maybe 20 to 25 times.
And has that been throughout the country in both state and federal courts?
Yes, I've testified in federal courts and state courts and also in Canada.
At this time, Your Honor, the defense would move to have Ms. Goddman admitted as an expert in question documents.
No objection from the state.
Ladies and gentlemen of the jury, the witness will be accepted as an expert witness in the area of question document examination. You may proceed.
Thank you, sir. Do you, in the course of your work with certain instruments?
Yes, I do.
Can you name some of the instruments that you work with?
Yes, there's certain tools that I work with regularly in my unit. One would be the ESDA machine, that's the electrostatic detection apparatus, and that's used to detect indented writing on documents. Another would be the video spectral comparator, that's also known as the VSC, video spectral comparator.
And what is that? What is that instrument?
That is a tool that document examiners use for a variety of reasons. That is basically a tool that is comprised of a variety of lights and filters, a camera, a computer, and a monitor. And using those different lights and filters, I'm able to see different parts of the spectrum of light and detect different things depending on what it is that I'm actually looking for on the document.
I can have it. I'd like to refer you to your report on December 22nd, 2008. Did you receive any items to test in this case?
Yes, I did.
Okay. And what items did you receive?
At that particular time, I received 3 pieces of tape, actually duct tape. They were identified as items Q62 through items Q64.
And what is your understanding that where these items came from?
It was my understanding that they came from the victim herself.
Do you have your report with you?
Yes, I do.
Okay. With the court's permission, can you look at your report and see exactly where the items were supposed to have come from?
Yes.
You may.
Thank you. It says that these items were received from the medical examiner's office.
Okay. And these were the items admitted into evidence Q62 through Q64, which I believe are...
State's Exhibit 302, Counsel.
302. Now, what were you asked to do or to look on these pieces of duct tape for?
The purpose of my examination with respect to these 3 items was to determine if I was able to detect a heart-shaped sticker or a sticker or any remnants from this sticker.
And did you use the video spectral comparator?
Yes, I did.
Okay. I'd like to now show you Defense Exhibit AU with a demonstrative aid. I don't believe we have an objection from the state, Judge. May I?
Is it in Counsel just talking about the photographs on that page,
Correct.
not the text?
Correct.
If she feels that she needs it, then I have no objection to it.
Okay.
I'd like to show you certain items, so you can explain to the ladies and gentlemen of the jury how this, I'll zoom in, so.
Could we just cover the text part since that's not really before the jury?
Sure.
Because I didn't think that was needed. It's just for the... Thanks.
No problem. Okay. Can I publish to the ladies and gentlemen of the jury, Judge?
Any objection to that being published as demonstrative aid?
No, sir.
Okay, we will publish.
Okay, the VCS, correct?
It's the VSC.
VSC, sorry. The VSC, can you explain to the ladies and gentlemen of the jury what they're looking at here and how this machine helps you in the course of your work?
Sure. The VSC, as I briefly explained, has a series of lights and filters. And what it does is it allows our eyes to see things that we wouldn't normally allow it to see. Our eyes as human beings see things between 400 and 700 nanometers. And we see things as different colors. We either see things as white if the light is reflected. We see things as black if the light is absorbed. And we see things as colors if it's a combination of absorption and reflection. That's between 400 and 700 nanometers. If we go outside of the 400 and 700 nanometers into the ultraviolet or infrared spectrum, which is before the 400 nanometers or above the 700 nanometers, where we don't see light, our eyes can't see it, but using these special lights and filters, we can allow our eyes to see things that we wouldn't normally see. So basically, by putting these documents under those lights and filters, we're able to see things without disturbing the documents or changing the documents that we wouldn't normally see. So basically, this is an example of just putting documents inside the video spectral comparator, which is just a box, and looking at these documents. And you can see with the naked eye, they would have just been white paper, but putting them in perhaps under ultraviolet light, they react differently, where one document is brighter than the other four. So in this particular case, there might have been, say, a 4-page contract or a 4-page will where there might have been a suspected insertion of a page. And in this particular case, one page is different than the other 3. We couldn't see that with the naked eye, but just using some different lights and filters that we wouldn't normally see with our own eyes, and just using this tool to aid us to see something that is outside of that 400 to 700 spectrum, we can see something that we wouldn't normally see.
So if somebody tried to pull a fast one on a will, you could spot it by using this instrument?
Right, it could be indicated that there's a different piece of paper.
Okay. And what does this example here show?
Well, this is an example on our right is shredded paper without using any different light except for normal everyday light. Then if you put it in the VSC, you can see that some of the pieces of shred are reacting differently than other pieces of the shred. And in our unit, we do put shredded paper back together. And so we can use this as a method to sort the paper. So it helps us to put the paper back together quickly if we can sort the pages by how they react in the VSC. We know which pages may go back together and which pages don't belong together.
And what about this example? What does this show you?
Well, this shows, again, on the right is a document that's been cut. There's two pieces where the page is cut, using the regular light, and then on the left are those two pieces, again, in the video spectral comparator, and there's some little paper fibers that are luminescing under the video spectral comparator, and we can use that to connect the pieces of paper back together, because these random paper fibers are actually in the paper, but they can't be seen with the naked eye. But using the VSC, we can see those paper fibers and show that those pieces of paper were at one time attached, because we can match them by these fluorescing or luminescing paper fibers.
And the last example that I'll ask you to explain, it appears something with matches here. What is that?
Yes. Well, matches from a matchbook have a lot of impurities and debris inside the matches, because all that happens is you strike a match and then throw the match away. So when they make matches, it's kind of the bottom of the barrel as far as paper is concerned. So there's a lot of impurities and debris in that paper. And because of that, there's a lot of fillers, and those fillers fluoresce under the ultraviolet light. So if there was, say, an arson case and that match is left at the crime scene and they get a suspect and they can find the matchbook either on the subject's in their pocket or back at their house, we can match those up again by the bottom. It's maybe a little hard to see here, but there's again some fluorescing pieces that we can line up using the video spectral comparator.
Okay. Tell us how you used the VSC in this case.
Well, in this case, I was unable to see any sticker or sticker fragment with the naked eye. So I went to the video spectral comparator to see if I could find any sticker fragment or remnants from the sticker using the video spectral comparator with some of the different lights and filters where I wasn't able to see it with the naked eye.
Would that include residue as well?
Yes.
Okay. I'm sorry, go ahead.
That's okay. Thinking that perhaps it was out of the normal range of my abilities, out of the 400 to 700 nanometers. So that was my thought, my intention.
Okay. And can you tell the ladies and gentlemen of the jury what the results of your examination were?
Well, after trying all the different lights and different filters, I was unable to detect any sticker or sticker fragment, sticker residue, utilizing the VSC.
Okay. Was there any evidence whatsoever of a sticker there on any of these pieces of duct tape?
No.
Now, after you had conducted your examination, were you ever asked to submit a DNA sample?
Yes.
Okay. And what was the reason for that?
Well, about a month later or so, I got a call from one of the analysts in the DNA unit, and she said that they had an unknown profile from one of the pieces of tape, and they were unable to eliminate it from anybody in their unit, and I suppose they have elimination samples, and it wasn't any of the suspects, so they wanted to know if they could get mine, and I readily complied.
Did you later find out that it was your profile on the duct tape?
I did, and it was.
Now, when you handled these items of evidence, did you handle them with care?
Yes.
And what precautions did you use when handling these items?
Our normal procedure is to wear gloves, and that is what I did.
Okay. And can you recall a situation where you believe you might have contaminated the duct tape? Or do you have no?
No, I have no idea how it happened or when in this particular case.
You at no time sneezed on it or anything like that?
No, sir.
Okay. And when you scanned these items, were they in protective plastic protectors?
Yes, in looking back at my scanned images, I did notice that they were scanned in their in the glassine, which is a protective plastic.
Okay. And throughout the entire time that you had these items of evidence, you of course exercised great care.
Yes.
Were you given other tests to run on any other items in this case?
Yes, I received other items later.
Okay. And I'd want to direct your attention to April 2nd, your report of April 2nd, 2008. And per stipulation, Judge, these items, I will just speak generally of them. Can you tell the ladies and gentlemen
from the state?
I believe we've listed the items in evidence by evidence number. I provided those to counsel. Those would be the items she's referring to. But there are items in evidence that probably should, just for the record, be designated so we're clear what we're talking about.
Sure.
Just some garbage bags.
And what we're referring to are states 294 through 299.
And I guess somebody's going to tell us what they are.
Yes, sir.
Okay. You may continue.
Can you tell us what you did, what you were asked to do in this report? If you want to refer to it, go ahead.
Okay. In the whole entire report?
Yes.
I was given a number of different pieces of plastic, and I was basically asked to just give an overall assessment of the plastic, as well as to compare some of the pieces of plastic with some of the other pieces of plastic.
And what were your ultimate conclusions? Were you able to make any matches on any of the plastic?
No, some of the pieces of plastic I was able to eliminate as having originated from one another, and others I was inconclusive on.
Okay. Were you able to match any of the plastic bags from the residence to the scene off Suburban Drive?
No.
I have no further questions, Judge.
Cross-examination.
You received the tape that was referred to a moment ago, States Exhibit 302, after the latent print unit had already examined it. Is that your understanding?
Yes.
So they had examined it, noted something, processed it, went back, tried to photograph it and find it. They couldn't photograph it and find it. You tried to find it. You couldn't find it either.
That's right.
That's the sum of that. As far as the bags, you were given a whole bunch of bags purportedly, and I'll fill this in, Judge, taken from the Anthony residence and compared them to some bags from the scene where the body was found. Is that generally what you were asked to do about these garbage bags?
There was just a couple of bags that I compared from, there was 5 bags from the residence that I compared to 2 items from the medical examiner's office. All of the bags from the scene, I didn't conduct a comparison.
The two items were two black plastic bags from the medical examiner's office. Is that correct?
Can you say that again?
Sorry. The two items in the medical examiner's office, those were two black plastic bags. Is that correct?
Yes.
For the jury to understand what we've been talking about.
Yes. Okay. And then there were two plastic bags that were known bags from the crime scene that I examined. But the majority of those bags from the crime scene, I didn't conduct a comparison of.
Okay. But in answering counsel's question, you were talking about looking at the bags from the medical examiner's office comparing to the bags from the Anthony house.
Right.
Is that correct? Okay. And you said, and the way you would compare bags is you would look at the fracture patterns in the ends of the bags to see if they could match up.
There's not quite. There's actually machine impressions in the bag as well as impurities in the bag that cross over from one to the other. So it's not actually a torn,
Okay.
It's not actually a tear on the end.
So some of them you can say, no, these were not from the same roll as the bags from the ME, and some it was just inconclusive, maybe not.
Right. Some were actually different in class characteristics. Maybe one was brown and one was black.
Right.
Those I could eliminate completely.
Right. But the other ones, it's just, you could be, maybe not.
Right.
No further questions.
Any redirect?
We were talking about the duct tape, ma'am. You mentioned that you were asked to, that DNA was going to be compared from the suspects. Did they indicate who the suspects were?
Sorry, objection. I believe she was asking about DNA comparison in cross.
It's about the duct tape. No further questions.
Anyone be excused?
Yes, sir.
Thank you, ma'am. You may be excused.
Thank you. May I go back to Virginia?
Yes, you may be excused. And
Yes, she
return
can go back to
home.
Virginia. May we approach briefly before the next witness is
Yes,
called?
you may.
Sir,
Just a second.
I'm sorry.
The defense may call the next witness.
The defense will call Carrie Oen.
This way, sir. Same here, raise your right hand.
Solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. My name is Carrie Oen, Caryoien.
Good afternoon, sir.
Good afternoon.
How are you employed, sir?
I'm currently employed as the section chief of the scientific analysis section of the FBI laboratory. Prior to that, I served as the unit chief of the firearms tool marks unit, unit chief of the trace evidence unit, and prior to that, I served as a forensic examiner in the trace evidence unit.
And how long have you been employed with the FBI?
I've been with the FBI just over 15 years.
And what is your educational background?
I have a bachelor's degree in biology and a Master of Science degree in entomology.
And have you received any specialized training in your field?
Yes, as a trace evidence examiner, specifically I was a hair and fiber examiner. I received over a year of on-the-job training at the FBI laboratory that involved lots of reading of scientific papers, books, lots of microscope time looking at different hair samples, fiber samples, learning how to identify hairs and fibers, then comparing hairs and fibers to each other and to known samples, oral examinations, microscopic examinations. At the completion of that training program, I was qualified as an examiner within the trace evidence unit, specifically within the field of hairs and fibers.
And when this case, did you receive any, well, actually before that, Your Honor, at this time I would move, unless there's any objection, to have Mr. Oen admitted as an expert in hair and fiber analysis.
No objection.
Ladies and gentlemen of the jury, the witness will be accepted as an expert witness in the area of hair and fiber analysis. You may continue.
When, in September of 2008, where were you working at?
At that time, I was the unit chief of the trace evidence unit, which means I was managing all of the trace evidence unit personnel, the forensic examiners and the physical scientists who work in the unit.
And would that include both Karen Lowe and Stephen Shaw?
Yes, it would.
Okay. And you were asked to conduct an examination in this case, were you not?
I did conduct an examination on this case, yes.
Okay. Tell the ladies and gentlemen of the jury what you did.
On this submission of evidence?
Correct.
Okay.
I'm specifically referring to your report of September 12, 2008.
A submission of evidence came into the laboratory. In this specific instance, the primary examiner, Ms. Lowe, was not present in the laboratory. As I was still a qualified examiner within the discipline, I was taking proficiency tests. I had an opportunity to conduct the analysis so that the evidence could move on and flow throughout the rest of the laboratory. The item of evidence was a shovel. I believe, may I look at my notes quickly?
I'm sorry. The state and the defense have agreed that the shovel is in fact the one testified to by Mr. Berner earlier in the trial.
I would agree.
Okay, thank you very much.
Thank
Specifically, it was our designation of Q46, a shovel. It was received into the trace evidence unit for a mineralogic examination, examined the stickers, the underside of the stickers using low power microscopy, removed debris that I felt was hair or fiber debris, mounted that on a glass microscope slide, and then did my analysis on the glass microscope slide.
Okay, and what were your conclusions?
On one of the stickers, it was specifically the sticker from the shaft of the shovel. I found a very small, approximately quarter-inch long or less, human hair that exhibited Caucasian characteristics on that sticker. The hair, based on the size and the limited nature of the hair, it was not suitable for me to compare to a known sample. So I could not do anything further other than to identify it was a fragment of hair, and then that fragment of hair was removed again from that microscope slide, and then I submitted it to the mitochondrial DNA analysis unit for their subsequent analysis.
And were you advised what the results of the mitochondrial DNA was?
I do not know what the results are, no.
Okay. Now, you mentioned that you are the section chief.
Yes.
Now, as part of the section chief, as part of your job as section chief, is it part of your job to ensure quality assurance within the quality control within the lab?
That is certainly one of the assets of the job. Within each of the case working units that are underneath me, they have unit chiefs that manage the unit, and they each have quality assurance personnel that ensure that the quality system for the laboratory and within each unit is specifically followed.
Now, your laboratory, is it what is called ASCLD certified?
It is ASCLD Lab accredited, yes.
Accredited. Okay, and what does that mean?
ASCLD Lab is an organization that will accredit a forensic laboratory. The accreditation process, there are many criteria that are established, and these are actually established by ISO.
What is ISO?
Loosely translated, it's the International Organization for Standardization. It's an international standard. But ASCLD Lab has these criteria that all the laboratories have to follow, and it's everything from the training that personnel need to have in order to qualify to work at a discipline. It's the competency tests that they have to go through. It's, do you have policies and procedures, standard operating procedures for how you conduct your analysis? Do you maintain your equipment? Do you calibrate and validate your equipment? There are management aspects. It's a very broad-reaching accreditation program. And when you volunteer as a laboratory to go through that, you volunteer to have an inspection team or an assessor team come in, assess you against all of those criteria, and determine whether or not you are meeting them.
Does a research lab have to go through these same type of rigorous criteria?
Can you be more specific?
Outside of their expertise, their examiner.
Sir, is that outside your area of expertise?
I was going to ask if you could be more specific on what he means by a research lab.
Okay.
Sir?
I can. If a laboratory is not accredited by ASCLD or another one of these organizations, are they pretty much on their own, or are they monitored like an ASCLD certified lab is?
Objection. May we approach? We have a
You may.
discovery issue.
Cross-examination.
So you found a quarter-inch hair in the back of a sticker.
That's correct.
Don't know who it came from?
That's correct.
Don't know how it got there?
That's correct.
Don't know how it's been there? Don't know how long it's been there?
That's correct.
Don't know what it means?
Other than it's a Caucasian hair fragment,
Okay.
no.
No further question.
Read.
Very brief. Fair to say you did a thorough examination of that item of evidence?
Yes, I did.
No further questions.
May the witness be excused. Thank you, sir. You may be excused.
Thank you, Your Honor.
Okay, ladies and gentlemen of the jury, that concludes the presentation for evidence today. We will be in recess for the evening. We will see you back here in the morning at 9 a.m. Please remember, do not discuss this case among yourselves nor with anyone else, along with all the other previous admonitions that I've given you. Any additional instructions on behalf of the state?
No, sir.
Or the defense?
Not from the defense, sir.
Members of the jury, you may be excused. You may be seated. Any other matters that we need to take up? Defense? Okay, see you tomorrow morning at 9 a.m.